My lord, may I be permitted to mention, my lord, item number 139 of today's list. This is extremely urgent. The district inspector of a school, my lord, pass an order by placing my service to an English medium school. I am a Bengali medium school my lord, teacher. And my lord, secondly, the few days back, on the same subject, another teacher was placed. There is no requirement for the teacher at that particular school. Your lordship kindly me to accommodate me, my lord. Otherwise, my lord, I am on medical leave. My lord, I have to. Your lordship kindly, my lord. But this order is out and out illegal. There is no rationalization policy at present. The government, it has been revoked in April 2005.
Where is the matter? 139?
139, my lord.
Next week it will appear.
Next
Week.
my lord, the next week, my lord, may be available in the next.
So somebody will be available even if the court is not there. What is the problem? That is not very important.
Friday, your lordship, can you?
No, impossible.
Lord, may I permitted to mention, I want to move an urgent motion. Lord, I am 100% blind, participated at the second SLST. Lord, applied for my lord, under PH category. Now after my lord, the verifications, my lord, the list has been published, my lord, under general category. 100% blind. I have paid 200 fees. My lord, I don't know, my lord,
an appeal has been preferred.
I know, but now it has been no stay order was granted. Kindly, my lord, in the meantime,
has the matter been heard?
No.
Then how can stay be granted? Let the matter be taken up. Possibly it will be taken up shortly. Just wait.
No, my lord, the EPTs, my lord, the interview list will be is published. Then, my lord, I will be. I will not be considered under PH category. Subject to result of this appeal, my lord, your lordship already passed an order. Your lordship already subject to result of this appeal. Your lordship kindly, my lord, take up this matter day after tomorrow. My lord, kindly grant leave, my lord, otherwise for 3 hours notice, my lord,
Friday.
Friday, my lord. My lord, it has not been affirmed. I am giving the slip, my lord, within half an hour, my lord.
I am seeking leave, my lord, to appear on 11th. SLST matters, my lord. Preliminary model answer key, final model answer key changed. I'm losing out for 1 mark. An interview on these 3 matters, my lord. I'm only seeking leave to let it appear on 11th because 48 hours time we are not getting. So, my lord, kindly.
No, but then 1 mark short. What can be done? There may be so many candidates with 1 mark short.
No, but because it is clearly, my lord, the model answer key has changed. Where books are showing there's a wrong question, wrongly done. We did not even get chance to apply. Okay, let it appear on 11th, my lord.
No, it will not appear on 11th.
My lord, leave may be granted, my lord, then Friday at least.
No.
My lord, kindly. Well, let it appear on 11th, my lord.
I have passed orders for revisiting the issue by the commission.
Yes,
right. I do not know whether an appeal has been preferred because each and every order is carried in appeal.
No, not yet.
And I don't know whether the order.
Let same order be passed. My lord, let same order be passed. That much.
You come on Monday.
My lord, Monday, my lord, kindly.
Nothing doing.
My lord, kindly on 11th, kindly, my lord.
No, 11th is impossible. 12th,
let it appear. I'm not seeking
are
hearing.
accommodated.
Let it appear, my lord. I'm not seeking for hearing. Let it appear at least. My lord, 48 hours time I will not get.
Where you will file it today?
Is it ready for this?
Ready, you file it in the department. Give the number. It will be.
No, 48 hours I will not get, my lord. It will not come on 11th. Unless your lordship grants me leave on 11th, I'll not get 48 hours.
I am not granting you leave.
My lord, kindly.
Do you get it?
Let it, my lord, kindly appear.
No, sir. You file it in the department. Let the number given. You
they will take 48
chance.
hours, my lord. Then
Nothing doing
on Friday.
Sorry. Yes.
Lordship, I'm mentioning for inclusion.
No, sorry.
My lord, may I permitted to mention for correction of the 2 order dates in the order copy? It is 24. It will be 25.
Item number 113, my lord. The medical transfer on medical ground. A petitioner undergone a kidney transplantation, my lord, in last November 2025. It is pending before the SSC, my lord. DI and school already forwarded after the medical examination, my lord. The petitioner is unable to attend the school regularly.
Since when?
First operation was held in 2022.
Then from 22 it is pending.
But again, November 17, again undergone the kidney transplant.
Yes.
Therefore,
Where is the matter?
113.
Today's list. Friday diye the to. Serve notice upon the learned advocate for the other side. Yes.
My lord, may I kindly mention this matter from inclusion.
No, inclusion's not permitting.
Upon notice to the state, may I mention one matter for arbitration from until is to be referred to. This is the CPF to CPF area pension matter from the date of retirement to the date of departure.
Yes. Which item number?
I don't know. So, 1305.
1305 CPF, GPF, the other one.
My
All right,
lord,
give notice upon your other side.
my
Call
lord,
the list.
it's blocked out.
And for the and for the petitioner, your lordship, matters for non-prosecution. This is the letter from my client, your lordship.
Item 2 in the original side.
On your lordship.
Original side.
2, 3, 4, 5. Item 10.
May it please your ladyship, this is an application.
So the appeal for the alleged proclaimer.
The notice has been, it has been served, my lord, pursuant to directions of your ladyship. Now, your ladyship, with a order dated, the order is at page 16, 28/8/2025. In view of, my lord, the undertaking, there was a query from the honorable court that the speaker was to respond. The speaker responded through the secretary. The order is at page 16. The relevant paragraphs, my lord, will be at page 17, para 5 and onwards. The query of the court has been replied to by the speaker through the secretary of the West Bengal Legislative Assembly by a letter dated 22nd July 2025, communicated to the learned Advocate General. Same has been retained with the records and a copy handed over to the learned counsel for the petitioners. Secretary of the Assembly has mentioned that entry of the personal security of all members of the House, including ministers, inside the Assembly House precincts is prohibited, and it has been published in the Bulletin Part 2 from time to time for information of the members. Aforesaid bulletins are applicable equally in respect of all members of the Legislative Assembly. As the Secretary of the Assembly has intimated the learned Advocate General that security arrangement is maintained equally for all members of the Legislative Assembly, irrespective of their political affiliation. Accordingly, the court is not inclined to proceed with the writ petition any further. Now, thereafter, para 9, the instant writ petition stands disposed of with the observation that all members of the Legislative Assembly shall be treated equally. Now, my lord, the solemn order was communicated immediately on the 29th of August. Your ladyship will find it at page 19. The Secretary, the Director General of Police, the CP Calcutta, the Commissioner of Police Calcutta, as well as the Director of Security, all were intimated about the order. It was further stated that it is also pertinent to mention that the security provided by the state authorities are also not allowed inside the Assembly House precincts, and security arrangement is to be maintained equally for all members of the Legislative Assembly. So this was also categorically indicated. Now, on the basis of such communication, in terms of the solemn order passed by your ladyship, page 20, my lord, a notice, my lord, was, my lord, affixed, my lord, in the assembly, on the assembly gate, my lord, page 20. It's in vernacular. As per directions, it is intimated that honorable ministers and honorable MLAs, personal security will not be permitted to enter the Assembly House precincts. That is the English translation. It's there, my lord, at page 28 also, my lord, the translated version. Now, despite that, on 4/9/2025, paras 5 and 6, my lord, of the petition, ladyship will find it at page 9 of the petition of the application. In willful and deliberate violation of the solemn judgment and order dated 28/8/2025, on 4/9/2025, the Honorable Chief Minister of West Bengal was permitted to enter the precincts of the West Bengal Legislative Assembly accompanied by her full security detail. At the same time, the security personnel attached to the MLAs of the opposition were denied entry into the assembly premises on the basis of a notice dated 30/8/2025 affixed on the gates of the assembly precincts stating that the personal security of the honorable ministers and honorable members are prohibited from entering the assembly precincts. So, my lord, para 6 is the further act, my lord. It is stated that the notice which was affixed, my lord, was a moonshine, and the chief minister also happens to be a member of legislative assembly. Despite the subsistence of, my lord, the solemn order, she was permitted to enter with the full security detail. We have enclosed, my lord, video footages along with the certification as required under the Evidence Act depicting such fact, and, my lord, violation of Article 14, which was, my lord, rather, I will say, my lord, bolstered by your ladyship's order, my lord, the contempt of which, my lord, has been filed against now, my lord. So, my lord, these are the acts of contempt, my lord, and, my lord, relying on the principle, the C-word principle, I say that not only the speaker and the secretary are guilty of contempt, but also, my lord, the Director General of Police, the Commissioner of Police, and the Director of Security, who were all made aware. They are all in contempt, my lord. This is a deliberate,
All right.
my lord.
Dear Lordship, may kindly have a look to my lord. The order of my lord, at page 16. The contempt jurisdiction is not a jurisdiction to settle political scores. Number one. Number two is, my lord, unless the list is decided, my lord, there is no contempt. Now, may I place the judgment? The instant writ petition has been filed by the petitioner number one, who is a member of the Legislative Assembly and leader of the opposition, and the petitioner number two, who is also
What
the.
is your defense? You please say.
My
Do
lord,
not read.
yes, first is, my lord, your lordship was not permitted, if I may use this expression, to decide my objection, because I had raised an objection regarding maintainability of the writ petition. Why? Because security arrangement within the Lok Sabha or Vidhan Sabha, where the state assembly, my lord, is not which is subject to judicial review by the court.
No, do not go back to all those things.
Yes,
Page
yes.
20 is one of the notices which has been affixed in the outer walls of the assembly, right?
Mhm.
Let this be followed. Where is the difficulty?
No, no, no. My lord, today, my lord, what is the contempt? Kindly see the acts of contempt which my learned friend has placed before my lord at page 5, page 9, para 5.
Yes.
This is his act of contempt, which is beyond the allegations in the writ petition. Please have a look to my paragraph 5, and I'll take your lordship through the writ petition as well. In willful and deliberate violation of the solemn order dated so and so, the chief minister was permitted to enter the precincts of the assembly with security attached to the MLAs. MLAs of the opposition bench were denied entry into the assembly premises on the basis of the notice dated so and so affixed on the gates. Then para 6 again he says that the chief minister was allowed to enter with full security.
Is page 20 not applicable for the chief minister?
Miller, page 20 in my very humble submission is not a judgment of the court, a direction of the court.
It is your direction, your notice, your publication.
Yes.
Let everybody follow it.
No, Millard, we are, Millard, distinguishing between, Millard, a constitutional authority. The speaker is a constitutional authority. Millard, the chief minister is a constitutional authority. Millard, the leader of the opposition or, Millard, the other members, they are not a constitutional authority in that sense.
What does in that sense mean?
Because the constitution does not recognize the leader of the opposition. Constitution recognizes, Millard, a speaker, a prime minister, a chief minister, a president. Therefore, Millard, if, Millard, some special arrangement.
What is the requirement? The house is secured. According to you, your police personnel have secured the house. What is the requirement of extra security inside the house?
That was precisely, Millard, my submission.
Right. It was
Yes.
your submission. Let that be followed.
My submission was, Millard, whether this can at all be gone into in judicial review.
The court is
That's why, Millard, your lordship was pleased to, Millard, keep the point of maintainability untouched. Your lordship was pleased not to decide.
Right.
Definitely, Millard. My learned friend, Millard, ought to have carried the appeal from this.
No, he is not aggrieved.
No, there is no direction also. Please have a look to me. The definition of civil contempt, Millard, as per, Millard, the Act. Kindly have a look to it. Please take me to section 2B. Where there has to be a judgment, decree, direction, which means that there has to be an adjudication. This way or that way there has to be an adjudication. Where the moment I raise a point of maintainability, your lordship was pleased not to decide that. And your lordship expected that everybody will be treated equally. Now this observation or this expectation, whether in a case it is found to be not as per the observation or the expectation or the desire of the court, whether it would lead to contempt or not. Well, on that I
Prior to that, you tell me whether there is any requirement of extra security inside the premises.
that is something which the speaker has to decide. The speaker has to feel.
That means the speaker felt that there was requirement of extra security, which is contrary to what you submitted in the writ petition.
No, yes. Now kindly comes back to the writ petition. The writ petition did not say that the chief minister was being favored and the leader of the opposition or the members of the opposition bench were disfavored or not favored. Kindly have a look to the writ petition now.
If I can remember correctly, allegation was that the members of the ruling party were permitted to enter with the security, and the opposition was not.
Yes. Now today that is not the grievance. Now, please have a look to the writ petition. Let us see the writ petition, how far he can extend
All
it.
these matters consume the court's precious time.
Lordship, he has been on some other day. Well, I quite
other
appreciate.
matters.
Well, I quite appreciate. That's why, on the previous 2 occasions when the matter came up, I said that you please take it on some other date so that I don't waste your lordship's time. And now I find your lordship is more hard pressed with the other matter. Kindly may I have but I can come back on some other day if your lordship.
Let them file an affidavit
no,
stating that
no.
the special privilege. Despite being an MLA.
I would first like to address your lordship.
Constitutional privilege.
But there's something called parliamentary privilege also. But I would have argued this, if my learned friend wanted me to address your lordship on that. This was what I intended to argue on the first date. Yes. Now, please have a look to the writ petition.
File an affidavit. There is no apology coming. So they intend to explain that there is no contempt. I'll be arguing on that also. The conduct of the speaker.
The secretary. If he is in hurry, I can come on some other day.
No hurry.
But this point has to be decided whether on the basis of some observation or expectation by the court, the contempt lies on them. But this is a question of law. This is a question of law, Kindly have a look to the writ petition. Page 4 of the writ petition, para 3.
I have got more important matters today.
Fix it some other day.
The SLST matters are
I know.
a lot of time.
Yes.
So some time has to be given to them.
Keep it on the reopening week,
Reopening
week. I think I don't know whether your lordship fixed the calendar or not.
Not yet.
Not yet.
You'll
So
get
keep
to know
it
if
keep
it's
it on the maybe the first Monday of the year, Monday or Tuesday.
Let them come back with an affidavit because
But I intend to.
On the previous 2 occasions, my lord, accommodation was sought for by the learned advocate general.
No.
Today he is not seeking accommodation.
No.
Today the court is hard pressed for
I
other
appreciate it, I
matters.
appreciate
That should be put
it.
on
But this
affidavit.
is a matter which can wait,
Yes, because we can otherwise we cannot deal with it unless and until there is an affidavit.
Please come. The instant contempt has been filed alleging violation of the direction passed in the order dated 28th August 2025. Stop. Learned AG opposes the contempt application
All the contempts.
and raises an issue with regard to the maintainability of the same.
All the contempt.
The matter is to be heard.
No.
Released 16th of January.
Very good.
It is a Friday.
Very good.
But in the meantime, let them file an affidavit, my lord.
Let us see.
I'm grateful, my lord.
But in the meantime, my lord, the winter session will be commencing, my lord. My lord, let the order be complied with. Let them purge themselves from the contempt, my lord. But let there be an observation, my lord, to that, my lord.
Are you feeling any security threat?
My lord, there is an order, my lord. We had
No,
argued the
tell-
matter, my lord, at length.
See, I am looking at the bigger side
Yes,
of it.
yes.
Are you feeling any security?
There were
threat?
supplementary affidavits indicating, my lord, the security breaches, my lord, which had taken place inside the assembly precincts.
In the writ petition.
Yes, the supplementary affidavit filed
In
for
the
the
writ
and
petition.
the application also, my lord. That
No,
was,
that was on
now-
21st of May.
Right.
no,
Right
it is
now.
admitted that it was on 21st of May.
Oh,
Right now, is there any security threat?
But now there is an order, my lord, from the honorable court, my lord.
Right.
It is on the basis of an undertaking, my lord, which has merged in the order. The undertaking specifies,
Are you having a security
but
threat?
as of now, the
please?
assembly is not in
All right.
session.
In case there is some difficulty, then
My
you
lord,
can
in
come.
the meantime, the solemn order has to be complied with, my lord.
They will.
Because
notify.
it is a brazen defiance, my lord.
Yes, yes. Please ensure that these matters are settled at your end only
yes, yes.
and not reaches the court.
Well, that is what I intended to, my
What
lord,
is sauce for the
address your lordship on the very first day.
Please see that there is
Well,
no
my lord,
security
I gave
breaches
this
and
example,
everything.
but I gave this example, if your lordship recollects, but how, my lord, Chief Justice will arrange the security in High Court, whether any other constitutional authority
Those
can
were
look
all
into
argued,
it.
my lord. Now, even, my lord, before
Yes, call the other.
I'm grateful, man.
Yes. Contempt.
Your lordship, we had mentioned the other day.
my application he is mentioning he can wait. It was an contempt of your lordship's order of 25th of August. I'll first highlight contempt and I'll also argue aggravated contempt, not because of 25th of August, your lordship will see the orders at page 100. Please have a look at the operative portion, Lord. A hearing had to be given by the insurance company to me because admittedly the court had found that there were certain things that they had not taken into consideration. It was a simple direction upon them. Paragraph 3, in view of the above, the instant writ petition is disposed of by directing the competent person, respond number 2, to consider the legal representation filed on behalf of the petitioner, annexed so-and-so, strictly in accordance with law and the insurance policy, covering the parties upon affording an opportunity of hearing to the representative of the petitioner at the earliest, but positively within a period of 8 weeks. This is dated 25th of August. I write to them, my lord, on 29th of August. I write to them on 24th of October. Time expires on 28th of October. 31st October, they write to me saying there's going to be a recalling application that we will file.
No.
That recalling application is dismissed because it was absolutely not maintainable. And that gets dismissed on 4th of November. So contempt straight away, 8 weeks not complied with. There is no answer to that. Now the aggravated contempt. Lord, please have a look at one notice of hearing that they give to me at page 111. Well, this in my respectful submission would be something where they try to add words to the order of the court and completely change the texture of the order. This is dated 21st of November. We write to you in furtherance of a direction so and so, way past 8 weeks. We requested you visit our office on 4th December to make your representations in terms of the aforesaid orders. Please note that no advocate lawyer shall be present from your side at the time of your representation. Your lordship's order allows me a representative. Then please see, we wish to explicitly state and bring to your notice that the respondent and its officials do not exercise any judicial or quasi-judicial functions in relation to the consideration of insurance claims and representations. The consideration of your representation shall be undertaken as a commercial contractual transaction. An administrative review of the claim in accordance with the applicable insurance regulations, statutory provisions, and express terms and conditions stipulated in insurance policy governing the parties. It is further stated that your representation shall be processed and dealt with strictly in accordance with the terms of the insurance contract, the Insurance Act, the IRDI regulations, and all applicable statutory contractual provisions. This proceeding is a matter of contract administration and dispute resolution within the commercial ambit, not a quasi-judicial adjudication.
Should you require any clarification, have any queries, please do not hesitate. What do? They completely, audaciously breach the order. It's supposed to be done by 24th of October. They don't do it. They file a recalling that gets rejected. And then comes this. This
All
is
right, let me hear.
Your Lordship, may I just, we filed a recalling application.
one more aspect before another notice has come asking me to appear today. But this they don't change. They will not allow me a representative in terms of your Lordship's order. And all this, my lord, this letter that they have given is really adding to the court's order, trying to make sure I am aware at a very personal level as who by device this must have been done. But this
4th of December,
yes, my lord.
did the hearing take place?
No, my lord, this
They did not appear, Your Lord.
we could not appear. We write to them saying you're adding. My lord, one is as a party, I can't extend the time that your Lordship had fixed.
Yes.
It was for them to come to court, especially when they moved the recalling. But even when they don't do that, and these conditions are really aggravated contempt.
All right, yes.
Your Lordship, may I just indicate? One thing is, if your Lordship sees the order, your Lord talks about a representation.
A very innocuous order, simple representation, consider and dispose.
Your Lordship, we had.
Why?
Yes,
this
Your Lordship, I
letter
have
has
no
been
idea
read
why.
out.
Yes, I have no idea.
And it appears as a threat that your client is giving out to the petitioners.
Your Lordship, the threat is on the other side. They are continuously writing to us, we'll contempt. They have 1 minute. Contrary to all Supreme Court judgments, which I've all got copies of, they have now made parties, my MD, everybody is being sent contempt notices.
Sir, there is an order of the court. Please comply.
I am complying today also. Let them come.
What do you mean to say today? The date has expired.
Yes, Your Lordship, we indicated when we had moved the application, Your Lordship will remember, but we filed this matter on 26th, the recalling, but there was the intervening court holidays.
Whatever.
Thereafter, Your Lordship, we had given them the notice to come and personally appear.
Thereafter is not enough.
Why personally the court has permitted a representative of the petitioner to remain present?
Yes, yes.
Why will you not permit?
We are permitting.
Your letter says no.
You're legal.
What legal?
Your Lordship will allow. Your Lordship, they had added the legal representation because they in their rules don't allow legal representation in any domestic or I think all of these things. That is part of them. They have written. If they had asked us that we want a legal representation.
There is a court's order.
Well, Your Lordship will go
to the client to add up to what is there in the court's order.
We are ready to comply.
Please come.
We are ready to comply.
Contempt also, Your Lordship will take up, because they are in breach of that.
Your Lordship, they are arm twisting. They're the only
apology.
Your Lordship,
no apology.
I tender apology. Your Lordship, I tender apology.
Service apology, my lord.
The order
This is not Mr. Sinha's personal action.
August 2025 is alleged to be violated. Stop. The communication made by the regional manager of the contemner. Is the regional manager one of the contemners?
Yes, my lord. Yes.
Saurabh Kumar Mukherjee.
Yes.
Of the respondent number 6. Appears to be contrary to the direction passed by the court. Stop. The court specifically permitted one of the representatives of the petitioner to be permitted opportunity of hearing. Permitted the petitioner to be represented by one of its representative in the hearing. Stop. The direction for consideration of the petitioner's representation has not been complied with till date. Stop. It has been brought to the notice of the court that today a hearing has been fixed. Stop. Can your client appear today?
Any other, Your Lordship, tomorrow,
Tomorrow
we will do it tomorrow also.
No. First, you explain why you haven't done it in 8 weeks.
The on the prayer of the learned advocate representing the contemners, time to comply the order is extended till 24th of December 2025. Stuff. An affidavit of compliance shall be filed before this court on the adjourned date. Released on 8th of January.
May I request for one line, Manoj, that this hearing shall be done in terms of your lordship's order.
Obviously, for how can they do
I
it?
don't think it's so obvious considering his conduct. All those letters that he's
Your lordship,
writing
I
now
give a
saying-
personal undertaking. I'll make sure that there is a legal representation.
Personal undertaking.
No, no,
The
if it's
court is not here to accept
Yes.
any personal undertaking.
nothing.
Personal undertaking.
আচ্ছা কি বললাম কিসের দিকে তারপর the direction is for complying the court's order.
Yes,
It means
yes.
everything is taken care of.
Very good. The affidavit of service we filed.
Yes. দেখো
May I please, your lordship, my lord? My lord, here the petitioner belongs to my lord civil cast.
other side service
The buyer wishes to show them. This is my utility.
yes
Physical copy handed over, my lord. My lord, here, my lord, the petition belongs to my lord civil caste category, my lord. I annex this civil caste.
are you there for the commission
Page, my lord, 20.
জলপাইগুড়ি matter
জলপাইগুড়ি
yes
Page 25, my lord. When I made an application before the authority, I categorically mentioned that I am, my lord, belonging to civil caste category. That is why I have paid my lesser fees as mentioned for the civil caste category. My lord, that subsequently it appears that the my lord concerned authority issued time to time notifications seeking, my lord, again clarification whether the my lord, the candidate is civil caste or civil caste. That period of time, my lord, here the writ petitioner failed to my lord submit his status of my lord his caste certificate.
Malad, this is SSC matters possible.
Yes.
Malad, this is SSC.
SSC
Malad, kindly just take it tomorrow. Kindly give it one copy, Malad, to us.
you don't have a copy
don't have a copy.
No,
তুমি
don't have.
দাও
আমাকে
No, no. I call you up. I have given in the office.
in your office? No, we have to check, Milord. Perhaps it has been given in the senior standing counsel's office, but not in.
No, senior standing council is a state. We are the SSC.
SSC has been served or
Yes,
not
ma'am. Yes. Service আরেকটা কপি দাও
This is Jalpaiguri bench matter.
yes জলপাইগুড়ি
Then kindly give us 1 day time, my lord.
Let it be tomorrow, Milord. We will just see.
will be taken up
I'll-
to
we'll do.
keep the affidavit of service with you then
তুমি না আমাকে সফট কপি হোয়াটসঅ্যাপ করো।
Send us.
yes item 1 non-prosecution
Prosecution, your lord. It's the letter to my client.
has the order been complied
Yes, your lordship. Order has been complied.
I am for the corporation, Lord.
and why do you seek for non-prosecution
Lordship,
If your lordship so says, then I have to check up. This is also very. I am not non-relying my learned sister, but in any manner, if your lordship should ask me, only if your lordship directs also, let liberty be given to us.
not pressed keep the communication on record I'm dismissing it as not pressed
But liberty may be
for what
that we can continue with the demolition,
who is stopping you
my lord.
Correction, my lord. Order date is wrong, my lord. Petitioner name and also, my lord.
all right সুব্রত বাবু আসুন। এই রীতা চট্টোপাধ্যায়ের সাথে রায় ছিল, দেখুন। এই হচ্ছে একটা কারেকশন, দুটো কারেকশন, তিনটে কারেকশন। অলরাইট, নেক্সট। সেম। Yes.
The petition correction of para 11. Year of tension.
All right, this may be given. একটা add up করতে হবে। Next.
I also say
অনিমেষ বাবু,
একটু দিন।
অনিমেষ বাবু, সামনে সামনে। All right, same. Same.
Same.
All right, same.
Great.
না দিতে Yes. Who's your other side? Who is he?
Supriya Chattopadhyay and Ms. Tapati Samanta.
All right. All right. Yes.
And the petitioner is challenging the notice of the district inspector, which is annexure P5. That because the petitioner's income is there is no income in the petitioner's family. The petitioner has only his younger sister and mother. And petitioner's father died in harness before attaining the 60 years of age at the age of 49 years. And the petitioner applied for assistant teacher, but it is for group T. They have served the notice for group T.
Assistant teacher, that
Yes.
way you cannot get it. Yes.
For compassionate appointment.
Yes, yes.
Petitioner's father was as an assistant teacher, and he died on 2014.
The page 5 is the impugned order?
Yes, Your Lordship.
My lord,
45.
sorry, I'm appearing on behalf of state.
Page 45 is the impugned order.
Yes.
And it's,
It is dated 2nd of September 2019.
yes, Your Lordship.
You have filed the writ petition in 2023.
23.
Why?
And petitioner came at that time.
It is not a matter of petitioner coming. But then 20, 21, 24 years after, this is you are seeking compassionate appointment. When did the employee expire?
Employee expired 2014. Thereafter,
14.
Thereafter, we have given all the documents and necessary documents to the respondent authorities. Page 30 is the format.
Oh, এটা প্রথমে পরেরটা আছে।
Page 30.
But page 29 and 30.
When was this submitted?
30th August 2023.
What is the submission?
My lord, it is order of rejection. At the material point of time, the income of the deceased family is 11,963, my lord. So, my lord, it is the initial gross salary of the.
Where from did the family earn 11,000?
My lord, that it is not here, my lord. It is my instruction.
The submission of the petition is that the family doesn't have an income at all.
My lord, I have received instruction from the DI, my lord. They are. It is.
What is the head? The head, 11,000. Where from is it coming?
That it is not here. Your lordship may kindly give me direction for filing. I want to file affidavit. They are saying 11,963 is the material point of time their family income. I do
From
not know.
where? You should inquire.
It is not here, my lord.
It may not be there, but you should have inquired where from is the income coming. It is not only writing that I have an income and you reject the claim. There has to be some source
My
of
lord,
the income. They must be getting the family pension. But how much is the family pension amount?
It is also not here, my lord.
Have you mentioned anywhere in the writ petition as to why you have approached this court at such delayed point of time? Is there any explanation?
No explanation.
Why will the court entertain the writ petition? 10 years have elapsed.
But thereafter we have sent representation.
After rejection, page 45, where is the representation? Let me see.
That after that, no.
Then your case got rejected in 2019. Where is the representation? Not a single representation.
No, not is annexed.
Please come. The petitioner seeks appointment on compassionate ground. Stop. Her father died in harness on 14th November 2014. 28th of November 2014. Stop. Application for providing appointment on compassionate ground was filed in January 2015, which stood rejected in September 2019 by the District Inspector of Schools, mentioning that the family income of the candidate was greater than the initial gross salary of Group D staff at the initial stage at the material point of time. Stop paragraph. According to the petitioner, comma, apart from the family pension, comma, there is no other source of income. Stop. On a query from the court as to why the petitioner approached this court more than 4 years after the order of rejection was passed, comma, there is no explanation to the same. Stop. The writ petition is also bereft of any explanation as to why the petitioner approached the court more than 4 years after her claim for providing compassionate appointment. Her claim for providing compassionate appointment stood rejected. Step next. According to service jurisprudence, comma, appointment on compassionate ground is not the regular mode of appointment. Stop. Compassionate appointment is provided on urgent basis to tide over the immediate financial crisis. faced by the family on the death of the breadwinner. Stop. The same is an exception to the regular mode of appointment. Stop. Paragraph. In the instant case, it appears that the teacher expired in November 2014 and the writ petition has been filed in the year 2023 in August 23, seeking setting aside of the order of rejection passed by the District Inspector of Schools in September 2019. Stop. In the absence of proper averments explaining the delay, comma, the court is not inclined to accept the prayer of the petitioner, directing reconsideration of her prayer for providing compassionate appointment. Stop. The delay in filing the instant writ petition is a fatal one. Stop. The writ petition accordingly stands dismissed. Next.
Deeply obliged.
Yes.
Item number 8, my lord, I am praying only not today, my lord, on behalf of Mr.
To appear
Chattopadhyay.
on behalf of the petitioner, my lord. This is also with regard to a rejection of an application for compassionate appointment. My lord, father died in 2015. Thereafter, the order of rejection was communicated to me in 2019. An unreasoned order. Thereafter, I made representation. No decision was taken.
Let me see the unreasoned order.
In 2022, after that, they have considered my representation. And in 2023, the
Where is the rejection?
Page 41, my lord.
page 41 is the rejection. However, they say that the wife of my mother is divorced and she's also a part of the family, and her status and her profession and her employment has to be taken into consideration for compassionate appointment. Lastly, the matter was taken up by Justice Basu, and he has directed us to file a supplementary affidavit indicating the present income. My lord, may I file
Indicating the present?
income certificate, my lord. This is that certificate.
Give.
Yes, copy there. Consideration number today also. So days of the time নিতে বলেছে আমাকে, তাই নোট করে দিলাম। আর কি হবে?
Yes, you want adjournment?
Today only, not today. Mr. Supriya Chattopadhyay is appearing in this matter. He has not come to court today.
Please
Only not
come.
today.
Supplementary affidavit filed on behalf of the petitioner in court today is taken on record. Has copy been served?
Yes, I have, sir.
Achha. And are you assisting Mr. Chattopadhyay?
My lord, I am in this matter I am recorded, but in this matter I am not on record, my lord. I may appear
Item
with Mr.
8 is going on.
Yes.
Are you there?
I may appear with Mr. Chattopadhyay.
May appear means?
My lord, somebody is there, my lord. He is not in the panel, my lord. So I can appear with Mr. Chattopadhyay.
All right. The order dated 17th February 2023, passed by the District Inspector of Schools. No, passed by the
No, mass education and extension.
Director of Mass Education Extension.
Yes.
West Bengal is impugned in the instant writ petition. Stop paragraph. The respondent authorities is directed, the respondent authority Korun, is directed to file a report by way of affidavit disclosing its stand. Stop such affidavit shall be prepared and circulated by 13th of January 2026. Release the matter for further consideration on 27th January 2026.
My lord. 27. I'm deeply amazed.
9, I am for the petitioner. Lord, the petitioner
Yes.
participated at the selection of upper primary teacher. When she was qualified, her name was included in the panel.
Okay.
But at the first counseling, she did not appear because the as first SLST, she was a teacher of 11-12. And my lord, the November 2024, she did not.
What do you want? Extension of time?
No, my lord, I tell you, my lord, after the first counseling, she approached after the judgment of the Honorable Supreme Court, she approached the chairman that to participate at the further counseling. My lord, the lawsuit can turn to page 40, identical matter, my lord, similar facts. My lord, the 11-12 teachers, my lord, I also kindly, my lord, consider that. Bharat, sorry, 90 days coverage. Kata recommendation.
SSC was directed to permit the petitioner to participate in the counseling scheduled on the 11th of June.
After that, my lord, about 30 writ petition were heard analogously by the coordinate bench and delivered a judgment, my lord, permitting them in the next counseling, whenever, my lord, it will be held.
No, then what
since
happened?
Then appeal was papered.
All right.
Since the appeal was pending, I mentioned, my lord, the appeal was pending. Ultimately, division bench, my honorable division bench dismissed the appeal. Logically, I have given the.
All right. Now what is to be
Now,
done?
my lord, similarly, my lord, the same footing, I want to participate at the counseling along with others. The petitioner is my lord, impanel candidate.
Was this matter also carried in appeal? This order?
No, it has been complied with. After that, my lord, the 30 writ petitions are filed. Mukti Vishwas, my lord, relying Mukti Vishwas, the honorable division bench, my lord, passed this order.
Oh, what is to be done? Commission?
The appeal was dismissed, but the court made it clear in the appeal. May I just place? This is page 4 of the order.
Yes.
The third paragraph.
Subject to availability of the matching vacancies.
Yes. The court also made it clear that in the peculiar facts and circumstances, this order is being passed. Now, this candidate, I admit that yes, the facts and circumstances are more or less the same, job losers. But otherwise, the court has held that the rule does not permit absentee
The
candidates.
court is not going to that extent.
Yes.
Last week orders were passed and those matters are possibly returnable today. It's there in the list. Right?
My
What
lord.
is your submission? Matching vacancies, are you all finding out matching vacancies?
Yes, that process is ongoing. That process is ongoing. It was fixed on the 8th yesterday, but because there was a possibility that that bench might not be sitting, they were not listed. After that, the matters were mentioned today in the morning, but the court has not given any particular date when they will be taken up. But the order remains that first the 1,242 candidates are to be filled up. Then, if there are any vacancies left, then we will call them for filling up the vacancies. That is the position.
That has been observed by the Honorable Division, phase 4 of the.
So what to do this with this candidate? Same order can be passed?
My lord.
Please come. The petitioner. না তার আগে লিখুন the facts relating to the instant case are more or less similar to the facts in the case of Mukti Bishwas, which has been decided by a coordinate bench of this court on 9th June 2025 in WPA 9980 of 2025. Stop. Paragraph. The present status of the writ petitioner is that of a job loser. In view of the order passed by the Honorable Supreme Court on 3rd April 2025 in SLP number ওটা দেখে বসিয়ে দেবেন তো State of West Bengal versus Boishakhi Bhattacharya Chatterjee. Yes. Stop. The petitioner seeks for a direction upon the commission to permit her to participate in the counseling process for the upper primary teachers. Stop. Next. It has been brought to the notice of the court that the counseling process is on and counseling for approximately 1242 candidates.
My lord, may I just kindly do not record that the counseling process is on because the panel expired on 24th September.
All
Now
right.
what is happening is pursuant to direction of the court in the contempt matter.
তাহলে counseling process is on ওটা কেটে দিন তো It has been brought to the notice of the court that in compliance of the direction passed by this court, counseling of 1242 candidates is going on. Stop. Next. The order passed by the Honorable Division Bench on 25th November 2025 in MAT 1512 of 2025 with IA number CAN 1 of 2025. Bracket open. The West Bengal Central School Service Commission and another versus Orpita Pramanik and others has been brought to the notice of this court where the Honorable Division Bench was pleased to permit that even after accommodation of the said 1242 candidates, if there are existing vacancies, then the same may be permitted to be filled up by allowing the candidates to participate in the counseling process subject to availability of matching vacancies.
Yes.
Stop. The direction passed by the Honorable Division Bench is reiterated in this matter. Stop. If after the counseling of the 1242 candidates, any vacancy subsists, then the petitioner may be permitted to participate in the counseling process subject to availability of the matching vacancies. The writ petition stands disposed of.
And let the opposition be kept on record. There was a direction.
Opposition filed by the Commission be retained with the records. এটা ফেরত দিয়ে দেবেন।
কাজের জিনিস
Could I appear on behalf of the petitioner? Last occasion, 28th of November, my lord has been pleased to direct the commission to take instruction why the appointment has not been given. Though recommendation made by the DI of school, decision was taken January 2024, and it was sent to the commission, page 73 on 18th March.
1 minute. Yes, commission was directed to take
Yes,
instruction.
my lord, I have taken instruction, my lord. My lord, petitioner has been enlisted, my lord, for Group C category post, female Bengali medium, in the district of Purba Medinipur. My lord, we have sought for vacancy by, my lord, our memo dated, my lord, 20th June 2025, requesting the board to, my lord, send, my lord, certain vacancies. My lord, thereafter, my lord, the board has sent some vacancies, but in the district of Purba Medinipur, no vacancy in the post of clerk has been sent. So, my lord, petitioner is, my lord, in the list. My lord, before petitioner, perhaps, my lord, more than 24 or 25 candidates are there. So, my lord,
Same category.
yes.
All Group C.
Group C. 45 candidates are, my lord, waiting in the queue. No vacancies there in the district. My lord, as and when, my lord, the vacancy will be available, my lord, we will say.
Vacancy available. That is part-time. Maybe
We will to ask.
There must be some vacancies, but it has not been sent.
Not been sent means he says vacancy has been sent, but there is no vacancy of clerk.
No, in respect of the district of Purba Medinipur,
not
vacancy has been sent.
No vacancy.
That district sent.
Submission is that vacancy status has been sent. There is no vacancy for clerk.
Yes.
This is what he submits.
পূর্ব মেদিনীপুর পাঠায়নি সেটা বল
পাঠিয়েছি রে বাবা sent, my lord, requisition has been sent to, my lord, the board. My lord, board has, my lord, subsequently in response to, my lord, our previous memo, previous requisition, sent some vacancies, but, my lord, in that list, my lord, there is no vacancy in the post of Group C in the district of.
I understand. So the vacancy list has been, oh, this was in June. Who's for the board? Yes, you produce the vacancy list the next day.
State is there, DI is there.
No, DI is there, but the vacancy status is to be.
DI is to collect the vacancy from the concerned school under this school or under his school.
Not in the same school. You can get service anywhere that is available.
Yes.
Then
under the district of Purba Medinipur, DI is the head of the district.
Yes.
He should know what is the vacancies available. In the district, now a situation, a large number of vacancies are there.
Who's for the state?
Your Lordship, I am led by Advocate Subhendu Bandyopadhyay. He is for the state.
Is he?
Your Lordship, he is not in court today because of his high fever. Also, as per my information, we still need to take direction from state. This is why I am praying for not today.
Last submission I couldn't follow.
We still need to take direction, Your Lordship. Instruction.
Instruction?
Yes, Lordship.
Why has instruction not been taken so far?
Your Lordship, I don't have proper information regarding that. My senior has informed me that much. Kindly make it not today.
This is a matter of compassionate appointment. You need to understand. Then, when can the when will the learned advocate be available?
Give me another date. I will inform.
The date means when?
As next date, any date you want.
Tomorrow.
Yes.
Tomorrow.
He'll come tomorrow?
Yes. Maybe I will inform him. He will come tomorrow.
গ্রুপ ডি পাঠিয়েছে গ্রুপ সি একটাও পাঠায়
না এই যে দেখো না গ্রুপ ডি
ঠিক আছে আমি পরে
Your Lordship,
Your vacancies are available.
Yes,
How can it be
I shall collect and I shall give the some vacancies in the area.
but that should be, my lord, more than 25.
They have to
Let us-
We are not the only.
because
Some-
24 persons are
Problem is
before.
the mother of the petitioner is also suffering from blood cancer.
What can be done? They have to maintain the sequence.
It is true, but considering the situation, mother died due to blood cancer.
All compassionate appointments are such. Right? Why will preference be shown?
Yes.
This cannot be done. Prayer for accommodation has been made on behalf of the learned advocate representing the state. Paragraph, learned advocate representing the commission submits upon instruction that from the vacancy status as has been forwarded by the West Bengal Board of Secondary Education, comma, there is no vacancy for the post of Group C in the district of Purva Medinipur. Stop paragraph. The board as well as the district inspector of schools both are directed to forward the current vacancy status of Group C in the district of Purva Medinipur. Stop. Release the matter for further consideration on 7th January 2026.
But if your lordship not give a time bound to the board and the DI.
তার আগে
Seventh
এর আগে হবে।
If your lordship directed the board and the DI to take to forward the vacancy within 15 days or not
Forward the vacancy where?
থাকলে তো দেবে।
To the commission.
They'll produce it before the court. Let us see if there is vacancy or not.
Milo.
Next.
Grateful to you.
Grateful.
Item number 11, I appear for the petitioner. Petitioner
11
Polash Babu, table.
item 11.
Number 11, my lord, I appear for
It
the
is same as item 9 yesterday. We have got the WP number. Your lordship has adjourned that matter till tomorrow on the prayer of Mr. Bandopadhyay, appearing for the commission. This matter may also appear together because the bone of contention is same, publication of untainted list.
yesterday, my lord, it was for 11, 12 and
Today
this
is for 9, 10. All other issues are same.
What happened before the division bench?
But it did not went up before the division bench. My lord, they have filed an SLP. What I came to know, maybe before the Supreme Court, just with the diary number, there is no stay or nothing like that in respect of Group C, Group D.
In the respect of other, there is a stay.
No, there is no stay. There is no stay. Only a diary number before the Supreme Court. As far as I know.
All right,
That is
then
in Group C.
tomorrow.
Group C, Group
If-
D.
But
9,
this
10,
is
11,
the
12, there is.
yesterday's item number 9, it may be appear together.
Let it appear tomorrow in that case.
In the fairly at the top. With this matter. This is 11, 12, this is 9, 10.
Even if it is not at the top, it will be taken up. Tagged. Not today.
Not today.
রেডি আছে তুমি আছো স্টেটে একটু ওকে নামটা দিয়ে দাও ওকে দিয়ে দাও ওই যে নিকেতকে দিয়ে দাও
Yes.
I am for this statement.
Commission.
The petitioner before your lordship is a handicapped person, visually handicapped. He was got an admit card for appear in 2016 examination, which has been cancelled by the Supreme Court. But I got written test second position out of 60, 57. Document was verified. I called for verification. In the verification, they have said, according to the new rules, your MA qualification number are not cross the 50%. Therefore, you will not be allowed. Well, your lordship will find last page 59. Last page 59.
You are Bulbul Ahmed Sharkar.
Yes, Bulbul Ahmed.
Right.
Your lordship 356.
Rejected due to PG score below 45%.
You are 45%.
All right.
But I am the candidate of visually handicapped, but 5% is relaxable. they have qualifying number has taken 50%. Therefore, it is 45%. Therefore, my lord, in this score, my lord, I was rejected. My contention is, as per the Supreme Court judgment, also your lordship's judgment.
No, no, lordship's judgment later on. Show me what the rule says.
My rule says, rule I have annexed. রোলটা আমি বলে দিচ্ছি। 2016, 16 September 2016 is the first rule which has been issued before 16 score.
Now the 2025 rules.
Yeah, that is also annexed.
Which
Yes, ma'am. Yes. Page 25.
Yes.
Page 23. Yes, ma'am. This is the rule. 29 May 2025. In this rule,
Mr. Arifin,
yes, ma'am.
please don't use your saliva to turn the pages. It's extremely unhygienic.
Oh, but
Don't do that.
no, I am sorry.
Where is your band? Where is your band? Is this your personal matter?
Well, I forget.
Forgot?
I have come in therefore.
Go wash your hand first. I'll not take up the matter today.
Just pass over only 2 minutes. I am getting one back.
Go wash your hand first.
The post offices nowadays have stopped. They give a disclaimer that don't use this system. Use water.
Especially after COVID, it's terrible.
This is my affidavit of something.
Yes.
এটা নিকালো নিকালো ইস্যুটা সেমই আছে ইস্যুটা সেমই আছে 13 item 13 age relaxation not selected.
Now, Milord, your lordship will be pleased to find that the judgment of Boishaki I need not, because your lordship has read more than me. Milord, I just paid 74 of the writ petition.
Yes.
Just after 3 lines, the 2 lines, other candidates who are not specifically tainted will also be eligible to participate in appropriate age relaxation. Then, Milord, it appears, Milord, I appear, then I do not belong in the tainted category, and then, Milord, this particular Milord notification of Milord 30th of May 2025, 1075. This was published. Now, there is, Milord, kindly consider one thing. Page 77, there is a condition that selection to the post of teachers for class 9 and 10 and 11 and 12 in school shall be made on the basis of written examination, evaluation of qualification of the candidate, oral interview and lecture demonstration to be determined by the commission
71
in the matter specified.
71
Therefore, there is no, Milord,
7
there is no, nothing has been specified that at any stage I can be singled out on the ground of being overaged. Now it appears, Milord, that I was called upon to appear in the written test. That my lord will be pleased to file. Milord, this I made an application. Now, Milord, the provisional admit card was issued. Can you see page 83?
ডাকলো কেন
Page 83. The provisional admit card.
You are participating for classes 9 and 10?
11, no,
11, 12.
11, 12 commerce.
All right.
Now, Milord, this is the particular admit card which was issued. I appeared in the examination. Now the result next page, can you come to page 84? This is very relevant. Why is that? Because, Milord, I had secured 35 marks and the cutoff marks is 18. As my lord got it, Milord. Then, Milord, your lordship may kindly consider that the list of particular Milord, a list was published wherein your lordship will be pleased to find that my name at page 85 appears in serial number 2. This is called the preliminary interview list under second SLST. Now, Milord, then Milord, there is another document I find that Milord, the verification of the documents, Milord, they did it, Milord, on 22nd of 11/2025. This is all going on, Milord, in terms of the particular, Milord, advertisement and also in the rules. I have nothing to say. Now, Milord, the last thing, Milord, your lordship may kindly consider that all on a sudden, Milord, they had issued a list of candidates to be disqualified for interview and lecture demonstration. It starts from, Milord, page 113, and Milord, my name, your lordship may kindly consider that my name appears in serial number 41 at page 103. Rejected due to overage.
Yes.
Miller, my first respectful submission is, Miller, I have checked out the rules as well as the particular, Miller, the notification which they issue. Miller, there is no provision of, Miller, the.
They have provided relaxation, I was told.
Miller?
It
Yes,
was shown
yes,
that
yes.
age relaxation has been given.
Yes, and that's the reason, Miller, that's the reason, Miller, that has been stated also in the order of the Supreme Court. That is the page, Miller, 74.
No, in which portion of the advertisement is this age relaxation given?
Miller, I say, Miller, kindly see.
Age relaxation will be given to the candidates who have been given the benefit of age relaxation as per the order of such and such of the Honorable Supreme Court. Did you disclose in your application that you were from the earlier batch?
Sir, I had given all my particulars.
Old number SLST 16 number is also there. Why was marks on account of your previous prior teaching experience not given to you? Did you not fill up the column for prior teaching experience?
Sir, I did it.
What you did it?
I will be showing also another document to my lords. That will
Experience score is 0. How come experience score is 0? Where is your application? Page 82. Where is the mention about your previous teaching experience?
Lord, it must be clarified that he was not one of them who was appointed.
Not appointed.
not appointed. That
All right.
He is unappointed, that category who has
Unappointed.
self-styled untainted.
Miller, there is no Miller because Miller they cannot take a different stand in a different manner.
That we'll argue. That we'll argue.
Yes, I followed. You are not appointed. I get it.
Whatever orders, Milord, were passed by the Honorable Supreme Court were for those, Milord, who were appointed and were permitted to continue till 30.
That is the way you are interpreting it.
This is our interpretation.
21st August to 29th August orders, Milord, we have handed over the compilation. It's with your lordship, Milord. Kindly speak. And it is also considered in, Milord, the Onima Pal's division bench judgment. And the compilation is
whether you will get the age relaxation or not. Now this is the issue.
Whether I was given the age relaxation or not.
Whether you will get the benefit of age relaxation.
I say, Miller, what your lordship is indicating, what came to my mind, subject to what also my lords can consider. Now, Miller, by permitting me to appear in the interview by issuing a letter and also the subsequent letter for interview, as well as for evaluation of the particular evaluation means Miller giving marks in respect of the particular Miller qualifications held by me.
No, it's all right, but then
At the stage of verification.
checking the your credentials, they found that you are overage.
At the stage of verification.
So you have been.
I cannot be disqualified because Miller in the particular date in the particular SLST 2016, Miller this particular aspect of the matter, Miller I was not Miller I was Miller singled out and Miller I have given
You are not singled out. There are several like you.
Miller, just 1 second, Miller. Miller, just 1 second.
What you want to find out, you say?
I want to find, Miller, I have also given a particular, Miller, information obtained under RTI.
Yes.
In Miller, it was indicated that, Miller, what was the particular, Miller, position so far as I am concerned.
Position means which position?
Page 33.
Which position you say?
Miller, my position in so far as after, Miller, the conducting the interview, what was my position? Because I wanted to ascertain
In the 2016 process.
in the 2016 process.
That process has gone.
Yes, I do not say anything. That process has been, Miller, has been quashed. Therefore, I cannot make. I only say that having regard to the particular observations, the particular candidate, if you do not belong to the tainted category, you have a right to particularly participate in so far as this particular selection is concerned. Therefore, I get a right to appear up to the stage of the entire selection process. Then if there are vacancies or if I qualify, then I will be considered. If not, my case will be singled out or I will be disqualified. This is my only submission. They cannot, Miller, at this stage, after permitting me to appear in the particular, because they have also indicated that, Miller, kindly for a Miller for a.
No. The thing which boils down is whether you will be provided age relaxation in terms of the Supreme Court's order or not. This is the one issue that is to be considered. There is nothing more.
Yes.
Right.
And the process has already started.
No, process has started that too in terms of the court's order.
Yes.
It's not that they are doing it on their own.
Yes, Miller.
Yes.
Today, if this departure is made by us, we will be hauled up by your Lordship's court as well as by the Supreme Court, because it every day various matters are coming up. We are under the Honorable Court's surveillance. The courts are vigilant about whatever we are doing. We can't make any conscious departure insofar as even someone has unknowingly, knowingly not knowingly participated. The School Service Commission might have called him.
No, his participation is not the thing. The issue
verification, on verification,
is whether the candidates who participated in the 2016 recruitment process can be given a chance to appear in the fresh selection process. Especially those who are not tainted.
No.
Tainted ones, gone.
Look,
a person, if he is not selected,
who are tainted? That is the question.
Tainted,
who is untainted? That's the question.
Is relatable to a selection. Someone is not even appointed.
Listen, do not make all this submission. The Supreme Court has set the matter at rest. Right.
Kindly sees the order dated 21st August. It's a part of your compilation. It's a part of the compilation. Kindly comes.
68.
68. Kindly comes.
268 at 269.
269.
Yes.
We direct.
Kindly read. I do not read it, Your Lordship.
No, read it so that he also gets
We
to know.
direct in the meanwhile all selected and appointed untainted candidates
Selected and appointed.
who were permitted to be continued in service till this shall be allowed to participate in the fresh process without insisting upon their complying with the newly introduced eligibility criteria of securing 50% marks in graduation, post-graduation, etc. This is this. All selected
and
appointed untainted candidates.
This is of 21st. See.
Then 25th August.
Then 25th August, the same direction.
271.
271.
Yes.
Same direction.
Then
The query of my lord.
And then 29th August.
277.
277.
We take on record. The second line.
Listen, this is specifically, this order is passed because you have changed or altered the minimum marks. This is the reason. Where is the direction that these candidates who participated in the 2016 recruitment process will not be permitted to participate? Where is that?
Malad, may I add something to what Mr. Bhattacharya is submitting? Malad, whenever the Honorable Supreme Court in these orders are mentioning about untainted candidates, the Honorable Supreme Court has used the words that selected and appointed, not only once.
Later on.
Yes,
Not in the
21st.
second order.
Yes, the main order has to be read, Malad. Kindly, Malad, take the main order, paragraph 3.
This is the 3rd of April's order?
3rd April's order in the writ petition at page 35. Malad, with the leave of my learned senior friend, Malad, I'm... No, but you are making submissions, so I'm sorry to just interrupt.
Paragraph 3, you
3. Yes. Now, kindly seize who were before the Honorable Supreme Court, Madam.
Yes, yes, I have seen.
The appellants before us are the selectees, some of whom have been working for over 5 years. They fall in two categories: selectees with purported evidence and material indicating wrongdoing, and other selectees who claim that they were validly selected and have committed no wrongdoing. The state and the commission have also challenged the impugned judgment. The respondents before us are the writ petition. Then 5. The implicated selectees have challenged the judgment on the following grounds. Therefore, the selectees were before the Honorable Supreme Court. The case of the selectees were being considered by the Honorable Supreme Court. Then, Malad, I'll come to paragraph 45 and 46. The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the service of tainted candidates were appointed must be terminated. They should be required to refund any salary or payment received. Since their appointments were the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to egregious violations and illegalities, which violated Article 14 and 16 of the Constitution. As such, the appointments of these candidates are cancelled. Therefore, again, Malad, what the Honorable Supreme Court is considering is the fallout of the recruitment. The fallout of the recruitment, the court was not considering the consequences on waitlisted and not waitlisted candidates, mere participants. This specific question, Malad, at the cost of repetition, Malad, was considered that what the Supreme Court meant when it said untainted candidates in Arunima Paul. In the compilation, Malad, again, if I may draw your Lordship's attention, in the Arunima Paul judgment, Malad.
Please see paragraph 30 at page 169 of Arunima Paul. Now, it is being specifically, Milord.
This point has been discussed.
Age relaxation point.
In the last order that I passed, which has been carried in appeal, if I can correctly remember what was passing through my mind, and that is there in the order also, that because of some tainted candidates in the list, there may be many others who could not make it to the list. Why will those candidates suffer?
Well, that exercise was never completed.
They
are participating in the recruitment process, not that you are giving some benefit to them.
We're not saying this, that with greatest of respect, perhaps that conclusion of your Lordship is prima facie. Your Lordship, that entire inquiry is not yet over. And the division bench of your Lordship's court, in connection with second SLST, has come to a categorical finding that in such background, in our respectful reading of the judgment of the Honorable Supreme Court, what my learned friend placed paragraph 49, age relaxation was allowed only to such candidates, categories of candidates who were appointed in the process. The parties before the Honorable Supreme Court were persons who were likely to lose their job or who had lost their jobs. It is the orders of the Supreme Court is not at the instance of persons who were not even selected in the process. And our division bench, in connection with the challenge to the rules, everything as a threshold, when the rules were promulgated, on
29th, 30th of May 2025. Thereafter, my lord, immediately writ petitions were presented in this honorable court. Ultimately, my lord, a division bench of this honorable court, your lordship, has innumerable times, my lord, been shown the relevant portions of the order. My lord, the relevant portion of the order, my lord, clearly, my lord, envisages that, my lord, on an interpretation by the honorable division bench, and this order was also, my lord, put to challenge before the honorable Supreme Court. My lord, there's no merger, my lord, it's a one-line dismissal. So, my lord, therefore, this order is, my lord, standing. And, my lord, our respectful reading of the honorable Supreme Court's order vis-a-vis, my lord, the entire process, whatever, my lord, was, my lord, at the instance of freshers may always apply, but freshers have to come within the parameters.
Yes, yes, certainly. The eligibility condition is there for the freshers,
And,
but
my lord, it
these
is for the
candidates.
authorities to also lay down what is the possible eligibility criteria. My lord, with all humility, my lord, the court is not poised with that expertise, my lord, as to what.
No, no, nothing of the sort. It is only
But
whether
age
the
relaxation
benefit.
part, my lord, is
Yes.
restricted only to untainted candidates who were actually selected and appointed. That is the interpretation given, and that is what possibly Mr. Bandyopadhyay was also.
No, my lord, what I was trying to, my lord, the point I was trying to, my lord, drive home was that the Honorable Supreme Court, that the Honorable Supreme Court fell short and stopped at the stage at paragraph 45 and 46 by saying that due to the egregious fraud, the recruitment process cannot be kept any longer. It has to be, entire thing has to be declared null and void. The Honorable Supreme Court did not go to the extent of saying that, look here, we have identified 6,000 to 800 tainted candidates. Let them be thrown out. And the waitlisted candidates be accommodated by so-and-so authorities. It was put to rest at the stage where the entire recruitment process was set aside. This stage did not come of accommodating the waitlisted candidates with the exclusion of the tainted candidates. Therefore, this exercise, which was taken up for the others of 26,000, OMR mismatch, etc., rank jumping, etc., that exercise was never undertaken as far as the waitlisted candidates are concerned. Therefore, my lord, when after paragraph 46, what comes is that the Honorable Supreme Court says that those who are not specifically tainted should be given an age relaxation. That is at paragraph 49, which only means that those candidates who were in the foray, who were given the appointment, and not those who had no vested right. This,
Anyway, Mr. Bhattacharya.
I will be only submitting because of two things. Kindly come to page 87. Milord, I say.
And I had one more submission, Milord.
When the phrase selection starts, there was issuance of the rules. Kindly see page 87. It's kindly see the date 29th of May 2025. This rules, Milord, of 2025 was interrupted. Now kindly come to Milord, rule 3 at page 89. There is a note. There is a note, age relaxation in connection with fresh selection process for recruitment of candidates for the post of assistant teacher for class 9, 10, 11, and 12. Comment pursuant to the directions contained in the judgment and order of the Honorable.
Whether you will get the benefit of this judgment.
Milord, I say, Milord, this is not the judgment, this is the rules. I am placing before my lords the rules.
No, no,
the rules speak of the
relaxation. Relaxation.
SSC has to comply.
The SSC is giving age relaxation in terms of the Supreme Court judgment.
Yes, yes, yes.
Do you fall within that?
Milord, I say, Milord, kindly see
the opposition stand is you don't.
Lordship has seen the first judgment. Then, Milord,
Hmm.
the particular other judgment, Milord, which your Lordship have noted it. Milord, I say, Milord, kindly see.
When this is to be decided, please come.
Kindly.
Petitioner participated in the second SLST 80 2025 examination and 2025 in respect of classes 11 and 12.
I say, Milord, with my deepest of respect, Milord, this is very disgraceful. A statutory body, Milord, takes any, they take it that they can play fast and loose, Milord, with any matter.
Though the petitioner was issued an admit card and his name has appeared in the interview list, but thereafter he has, not he or she, it's a he or a she. Acha, he has been disqualified for interview and lecture demonstration after the verification phase on the ground that he is overaged. Step. The petitioner submits that he should be given the benefit of age relaxation in terms of the direction passed by the Honorable Supreme Court on 3rd April 2025 in Civil Appeal number 4300 of 2024. Stop. Paragraph. According to the respondents, comma, the benefit of age relaxation cannot be extended to the petitioner. Stop. Paragraph. Whether the petitioner will get the benefit of age relaxation has to be decided. Stop. Let the matter appear in the list for further hearing on 13th of January 2026. Any steps taken? Now, the candidature of the petitioner shall abide by the result of the instant writ petition. Please take this back. Otherwise, every day you all are giving me one and it's going with the briefs.
One can be kept with Millard for all.
Right.
Not once.
Next.
Your lordship did not permit Millard, the client Millard, to appear without prejudice to rights and content.
No.
Then your lordship may kindly ask the School Service Commission Millard to place before the court as to whether Millard really fall.
No, you don't. It is their stand. You have to make out a case that you fall. Did you get it?
Yes.
Otherwise, it cannot be helped.
But I say, Millard, with the greatest of respect, Millard, that I have very little experience, but I say that these things, after perusing the documents, and more particularly after perusing the action of the SSC, how I can be, Millard, in this situation, Millard, not permitted. I only say that permit me to appear in the particular interview. Nothing else.
There are so many candidates like you. You are not the single one.
Not because there is a list. Yes, there is a list. And this
the lists are coming up in phases.
Examination in different matters.
The lists are coming in phases. There are many candidates. You are not single-handedly shutted out. Yes, call the list, please.
That Passover matter.
The Passover matter. Who was there?
I'm both still.
Yes. What is it?
That marks. MA qualification.
MA qualification marks?
In 2016 selection process is 45%. And new rule he has been published in 2025 that has been increased in 45 to 50%. Therefore, as per the Supreme Court decision, what is the notification in 2016?
Were you appointed? Were you appointed in the last selection process?
No, I was not appointed. I was disqualified. Therefore, my lord, I have also.
I did not follow. Disqualify means?
Well, I am not qualified in 2016 selection.
You were not qualified.
But I was appear. I was not qualified at
Yes.
that time. MA, that is
right. Now, whether you will get the benefit of the relaxations and everything, the court has to decide.
Yes, Lord, as we are participated, all the participation, not those who are not tempted, they can appear before the new selection. Therefore, Lord, admit card was issued.
It is just the same as the earlier matter.
Verification was made. Last of all, they have said at the time of verification, last annexure I have annexed, that you are not qualified, you are the
Please come.
Rejected to the PG 45.
আগের অর্ডারের প্রথম দিকটা যেটা বলেছিলাম না
Last page of 59.
Has appeared in the interview list. Thereafter, he has been disqualified for interview and lecture demonstration after the verification phase on the ground that he is overaged.
এখানে he is overaged এর জায়গায় rejected due to PG score below 45%. এই রিজেক্টেড ডিউ টু পিজি স্কোর বিলো 45 টাকা একটা সিঙ্গেল কোটস এর ভেতরে দিয়ে দেবেন পেজ 59। ঠিক আছে, তারপর কি বলেছিলাম?
Submits that he should be given a benefit of age relaxation.
এখানে এজ রিল্যাক্সেশন হবে না, হি শুড বি গিভেন দ্য বেনিফিট অফ দি জাজমেন্ট। এজ রিল্যাক্সেশন কতটা হবে না? হ্যাঁ, রাইট। এত
According to the respondent, the benefit of age relaxation.
the benefit the benefit according to the petition, according to the respondents, the petitioners cannot be provided any relaxation with regard to his educational qualification in terms of the judgment passed by the Honorable Supreme Court. ঠিক আছে, তারপর it is to be decided.
I am the handicapped person according to the NCT rules, but I have annexed that my qualification.
Is there any special benefit for handicapped persons?
Yes.
PH candidates?
5% number.
Candidate, there is a reservation.
Reservation.
No, not reservation as such. The eligibility criteria relaxation.
I don't think so. I just
Yes.
checked.
Yes, but I have NCT.
Mr. Singh, are you aware?
5% relaxation in advertisement is given.
5%, he got 45. Will he come?
5% from 50 because he is not eligible for the relaxation. He is not eligible for the previously the rules provided for 45% marks, NCT rules. Now it is 50%. So if he is eligible for relaxation as per the Supreme Court's order, then actual will be 45 and then he'll be 5% relaxed further. So then he'll be in cutoff. But if he is not eligible for relaxation, then 5% will be from 50%.
All right. তার মানে কি বললাম?
So that one I have challenged that 50%.
From
13th of January, please come.
The civil appeal number has
4800 4800.
candidature of the person allowed by the
January. Plus, what I pray, any interim order will be given one post.
Interim order is given that your candidature shall abide by the result of the writ petition.
And then, if it is one postage vacant ballot there, my case is very strong.
All right. Next.
My lord, I'm for the petitioner. Here the case is, my lord, the petitioner had applied for second SLST exam under the ACST category, but their caste has been wrongly updated as general one. My lord, the same one identified.
Show your application form.
My lord, my application is on page 25 onwards. And in page 89, their category has been stated as general, updated incorrectly. From page 89 onwards, an identical order has been passed by this court regarding such. It to my lord. Similar fact, my lord.
What is page 81? Jadab Chandra Mondal, who is he?
My lord, the petitioners, my lord. There are 10 petitioners, my lord.
How many court fees have you paid?
My lord, you have paid the court fees on online, my lord.
How much? You have the receipt?
No, my lord. Right now, I don't have the receipt, my lord.
There are
How many court fees paid? Huh? One. Only you've paid only one court fees. You have to pay the deficit court fees.
My lord, then.
When is your date of verification of credentials?
The date of verification is
Is the commission aware when is the date of verification?
For the date, my lord, there are two things which I would like to point out. First is, my lord, there are petitioners who have marked and applied in general category.
Where are they?
My lord, will kindly take up page 46. 46.
46, yes.
47, my lord, will take up. 47 is also general.
46 category is general, but the application fees shows SC, ST, PH.
No, my lord, that is the application fees, but he has applied on the general category.
no, my lord. They have paid, my lord, 200, which was prescribed for SC, ST, my lord.
I have seen that. I have seen that.
And there is, my lord, they have caste certificate as well, my lord. Page 79 onwards.
My lord, page 56 is also general. 57 is also general. 73 is also general. If it is kept day after tomorrow, my lord, because the honorable division bench has been pleased to fix the
All right.
appeal, my lord.
The instant writ petition has been filed by 10 petitioners by submitting only one court fees. Stop. Learned advocate on record of the petitioner is directed to deposit the deficit court fees by tomorrow. Huh? Cost title amend হবে? Othersটা লেখা নেই, yes. কি বললাম? Day after tomorrow, না? By tomorrow. Released matter on 11th.
Grateful, my lord.
Stop. Let the cost title, অনিমেষ বাবু, এটা দেখুন তো cost জন্য কি ডিরেকশন দিতে হবে? আপনি কম্পিউটার
তুমি take copy. You take copy, take. Grateful, my lord.
Well, I am for the petition, my lord. Notice for upgradation, my lord. Well, matters relate to the higher scale of pay, my lord.
You are for the state?
I am led by Wasim Ahmed. He is
All right.
for which is
On a higher scale of pay, my lord.
he is seriously ill, for which he is not court, my lord.
You are there?
Yes, ma'am.
All right. Yes.
My lord, the matters relate to higher scale of pay. My petitioner, my lord, made the representation before the DI, page 52, is pending for consideration, my lord. My lord, your lordship passed a similar order.
Page 52.
52. Last representation. my lord.
This is Nodia. This is
Purva
Purva Bardhaman. All right. Same order can be passed.
DI report on it, ma'am. Report দিল। Consider consider. Yeah, he's 50 বলছে, right?
There is a report from the DI which mentions about
About 50 years.
a government order which prescribes that henceforth no permission will be accorded for securing higher qualification to teachers over 50 years of age. Has that been taken into consideration in Utpal Kanti Karan? The age factor?
I think, my lord,
No.
In the affidavit, they have written 44 years, my lord.
let you consider, my lord.
44 years?
Yes, my lord. In the affidavit, it is mentioned 44 years.
Then how is this over 50 years coming?
There is something wrong, my lord.
Something wrong?
Yes, my lord. Because they have stated they are 44 years, my lord. In the affidavit, page number.
What is your age?
44, man.
That is written in the affidavit. Who's wrong? Nobody knows.
The petitioner himself affirmed, man.
Yes, my lord. In this page, my lord.
Page
Page 25, my lord.
But his approval is also there, man. Page 37.
No, if it is 44 years, then how can the restriction over 50 years be applicable? Sir, Ajay, please come. এই অর্ডারটা হবে
Date of
with the
birth is
correction.
17th October 1980.
এইটা এখানে থাকবে। Instructor line add up করে দিন। Instruction forwarded by the District Inspector of Schools, Secondary Education, Purbo Bardhaman, be written with the records.
Report আছে?
ঠিক আছে? The একটা paragraph add up করুন ওখানে। It appears that the District Inspector of Schools have applied the memo dated 27th, not memo, the government order 593/SE within bracket caps B dated 27th November 2007 এখানে আছে that no permission will be accorded for securing higher qualification to teachers over 50 years of age.
There is no observation, man. 593.
Stop. Next. Learned advocate for the petitioner submits that the petitioner is below 50 years of age, for which the aforesaid government order cannot be made applicable in his case. Yes, sir. Disposed. Who are you appearing for?
No, in the next match.
Okay. Yes.
Same matter, man.
Same matter.
It can be considered.
Any instruction?
Instruction is there, but my lord, it should be considered.
It should be considered. Where is your representation?
Page 46, man.
Which DI?
Nodia.
Nodia.
Then this order can go down. It is Nodia only. এটা সেম হবে ডিআই নদিয়া করা আছে।
My affidavit is already kept on.
Yes. Service taken on record.
This matter pertains to, my lord, extension of validity of recommendation in respect of upper primary selection.
Can the same order be passed as was passed in the other matter?
Firstly, I'm opposing this because the extension of the recommendation letter, it varies case to case, whether the candidates came within 90 days, after 90 days, after the extended period, 150 days, etc. Moreover, what fell from the court while hearing the first matter, that whether the candidate had mentioned that he or she is a job loser. Now we have scrutinized all the records. In some of the cases, they have specifically said. In some of the cases, it can be clearly inferred because they have at least mentioned that we were working in the 2016 selection process. Some of them are absolutely silent, though they were actually job losers.
Now,
How could you ascertain that they were job losers if they do not aver it? In
the reputation they have.
they have.
So 4 candidates have not mentioned even that they were job losers. So each case has been dealt with.
For
These
job
orders have been passed.
For
rejected.
job losers, are you all right with the order that was passed in the morning?
So in the morning, the matter
Matching
was referred to a
vacancies.
substantive candidate. So they have certain orders in their support. Now, if we extend the same logic to the person who came, participated, but did not join, then a different category of candidates are now getting into the.
The idea is to fill up the vacancies.
That
And
is running a shortage of. So that
if you do not have vacancy, there is no question of permitting any counseling or anything. It is the earlier order was also of the same line.
Passed an order.
1 minute. That if the vacancies subsist, available vacancies are there, matching to the qualification, then only. Otherwise, no.
Yes, yes. And my lord is passed similar order, the Concord Park. Subject to the availability of the vacancies. And there is the division bench order.
Subject to availability is not the only thing. If I have to process 200, 300 extra candidates in a future exercise where I have no vacancy.
Take up your vacancy list first. Then only
I had submitted
1242 is to be filled up.
on the last day that unless that exercise is complete, then we cannot say that what vacancies we have in our hands.
That was the reason why time limit was not fixed.
Yes.
Right. But then at least do some work. What is to be done?
Let me give one proposal. Since the issue of 1242 has not yet been resolved, which is before the court, let these matters appear in January. In the meantime, let me do a candidate-wise report for each candidate. Let me file it in the form of a affidavit. And then let us treat them candidate-wise. In the meantime, if the vacancy problem is also solved, that can also be solved.
My lord, subject to correction of line learned friend, my lord can pass disposed of by this observing the same. My lord is categorically stated if the vacancy of the 5,300 vacancies in their hand, it is not my submission, it is submission before the honorable division bench. Candidates left, my lord, at about my lord 1,300 or my lord 1,400, not more than. So they have 4,000 vacancies in their hand, and honorable division bench observed there is no future vacancy, there is no future advertisement in the upper primary selection process. That is why, my lord, honorable division bench passed the necessary direction for conversion. So, my lord, if I am claiming not any period, if there is subject verification, availability subject to availability of the vacancy, if the vacancies match, they can accommodate it. Since my lord has also passed, division bench is saying job losers are all are job losers. In this candidate, my lord, they may not mention, but
the entire set.
Yes, all
everybody,
job
all job
yes,
losers.
all job losers, all job losers. And all reason order is the same.
Please
Reason
come.
order they have passed same by observing the same.
New avenue is open, then the number of candidates which will now come before the commission will be enlarged to such an extent it will be very difficult for us to handle. Absentee candidates could not attend due to a very specific reason.
In furtherance of the direction passed by the court on 4th December 2025, a learned advocate representing the commission submits that the process of filling up the 1242 vacancies is continuing in compliance of the direction passed by the court.
My lord, figure is here if you lords.
Stop, I do not want the figures. ঠিক আছে? passed by the court. It has been submitted that the panel in question, where the name of the petitioner featured, expired in September 2025. Stop. At this stage, there is no scope for extending the period of recommendation in favor of the petitioner who deliberately did not join the service in terms of the recommendation. Stop paragraph. It appears that the petitioner is a job loser who lost the job in terms of the judgment passed by the Honorable Supreme Court on 3rd of April 2025 in Civil Appeal number 4800 of 2024. Within bracket, Boishaki Bhattacharya, within bracket Chatterjee. Now, State of West Bengal versus Boishaki. ঠিক আছে? Stop. Let me see the appeal court's order once. Attention of the court has been drawn to the order passed by the Honorable Division Bench of this court on 25th November 2025 in MAT 1512 of 2025 with IA number CAN 1 of 2025. Within bracket, the West Bengal Central School Service Commission and another versus Orpita Pramanik and others. Wherein the court took note of the fact that the petitioner was empaneled and she came within the listed vacancies of the commission. Stop. But as the candidate was absent on the date of the personality test, absent in the process of counseling, personality hobe na, process of counseling, comma, the recommendation letter lapsed. Stop. Under such circumstances, the court directed, not the court, the Honorable Division Bench directed the commission to permit counseling of the said candidate with a rider that the participation in counseling shall be subject to availability of matching vacancies. Stop paragraph. In the instant case, keeping in mind the current jobless status of the petitioner and the fact that the petitioner was recommended by the commission for appointment in a school. Accordingly, the commission is directed to take a sympathetic view of the matter. Stop. The commission is directed to permit counseling of the petitioner subject to availability of matching vacancies only after the 1242 vacancies are filled up. Clear?
Yes,
My
absolutely.
lord, counseling, subject to correction, counseling already over. Recounseling, my lord, possibly
Is not required. Recommendation.
recommendation.
আচ্ছা এখন তো লাস্টেরটা কি বললাম একটু বলুন তো
The commission is directed to permit counseling of
না
the
to recommend the petitioner.
Yes.
Only one thing, this should be allowed only after we have completed.
I have mentioned that.
242, but the other absentee candidates who have the orders of court, because they will not be called for counseling. They, if their vacancies are still there,
Yes, yes, yes.
then only will they be called. That at least I think
You think over and all new points will come to your mind. So what is important is matching vacancies. That is the key thing.
that is the only thing which is saving me, actually.
Disposed of.
My lord, only one thing, my lord, since they have already passed and reasoned order, that, my lord,
Acha.
we consider.
In all the matters,
All the matter, reasoned order.
Acha. The impugned order of rejection for extension of the recommendation letter, for extension of the period mentioned in the recommendation letter stands set aside.
My lord, up to
1 minute. One by one, state council's appearance will be required. আপনি একটু থাকুন 1 minute. Pradeep, take note. এই অর্ডারটা হলো item 17. Same order will go down from 18 to 37. Only the state councils. It will be called on one by one. Don't hurry. Only the state council's appearance will change. Order is there. Whoever can take it. ঠিক আছে? Call one by one. 18. State. File দিতে হবে না. State. Nobody is there.
I'm for the state, my lord. In
Oh.
item number 18, my lord.
Pradeep, item number 18, State Council is there online. Yes, 19.
I'm for the state.
Give your appearance, please. And anybody who is not present in court, please do not put in the appearances. 19. Next.
I'm for the petition.
20. দিয়েছে?
I'm for the state, my lord.
Please put in your appearance. Please check up whoever is not there. The list. Yes. 21.
21, I'm for the state.
Give your appearance. 22.
I'm for the.
Okay. Nahi. Is Mr. Shahi there? Who has given the name of Mr. Shahi? Who is the junior advocate to Mr. Shahi?
I'm here, my lord. My name is Mr. Supriya Majumdar, my lord.
Who is the junior counsel?
Mr. Shahi, Your Lordship.
Yes. Where is Mr. Shahi?
Lordship is engaged in some other court.
Then he is not here. Please do not give the names of anybody who is not here in court. Got it? Next.
My lord, I'm for the petition.
Nobody for the state. 25.
No, 24
Oh,
I am for the
24.
state, Lordship.
আচ্ছা ঠিক আছে
24 I
24.
am for the state.
Is somebody assisting you? Mr.
Lordship,
Boisho?
here, Lordship, Mr. Ghosh is here, Lordship.
Yes, Mr. Ghosh
Mr.
is here.
Minal Ghosh.
Yes, he's here.
24, Lordship.
25. 25, nobody is there. 26.
I'm for the petition.
None. 27.
I'm for the petition.
Nobody. 28.
Lordship, I am for the state 28, Lordship.
28, record
Mr.
appearance.
Ranjan Saha.
Mr. Shaha is not here.
The Lordship, put my name.
Your name will be there.
Oh, Lordship.
29. Give your name. Yes. All right, all right. Thirty-one. Give. For the state. 32.
Madam, for the petition.
32, I am appearing for the state. Give your appearance slip. 33.
I'm for.
Give. Next, 34.
My lord, in this matter, my lord, Mr. Rausi was appearing in this matter, my lord. Now, money matter is running, my lord. Court number 8, my lord, division bench.
Call him.
What is coming, my lord?
All right, call him.
Coming.
Slip to Nenin.
Coming.
Nenin.
Yes,
Yes, all right.
Waiting on my name.
34. Who are you appearing for? 34. Somebody else is there.
My lord, but he's appearing with me.
All right.
My-
Spelling mistake to be rectified in 34. Record an order, Pradeep.
Accordingly, I'm for the statement.
Yes. 36.
I'm for the state.
Yes.
It is complete.
37.
37 is transferred.
Oh, transfer. It's separate matter. 36 is the same order. Yes, 37. Who's for the respondent?
At last occasion, your lordship directed to serve notice upon the state authority.
Who is appearing?
My lord, it is appeared from Ashish Guo and Norin Ghosh. Mr. Ashish.
Mr. Ashish Guho, he was here just now. Wait, call him. His matter is going on.
My lord, transfer application. My lord, I am an assistant teacher in my lord history in HS section. History, my lord, I am single teacher in HS section, but in normal section there are PG categories teachers in histories are there. My lord, so as per the decision of the honorable division bench, my lord, I cannot be treated as a single teacher.
You cannot be treated as
a single teacher since there is other
Hello?
rule definition or rule as per rule. If the resultant vacancy is 0. So my lord, the rule is clear. So since there is other teacher,
I did not follow.
My lord, I am the assistant teacher in history in HS section.
Yes.
There are 4 other assistant teacher in history in normal section in the school.
Normal section means
up to
class
10, up to 10, and they have the PG qualification.
They have the PG qualification.
They can teach the HS section. So I cannot be treated as a single teacher. My transfer application turned down by
No,
the
I
school
did not
authority.
follow it. You are there in this matter, item 37.
My lord, notice is there, my lord. I have sent.
I have missed it, my lord.
You've missed it. There was a direction upon you to take instruction. Are you sure he's there? He doesn't know he's there.
My lord, there is an order, my lord. Last, there is kindly see that order.
No,
earlier order, my lord. No. They have appeared in last first occasion.
Yes. Ashish Go, Noran Ghosh, Dostidar, I can see your names.
So make it not today, my lord.
Not to not service the
January.
He needs to take instruction.
January. Kindly fixed up a date.
Please come. Learned advocate for the state is not ready with proper instruction. Stop. Let instruction be obtained from the District Inspector of Schools, Secondary Education, Murshidabad, regarding the vacancy position in the subject school. Stop. The
37.
not the instruction shall be forwarded as to whether the petitioner is a single subject teacher in history in the school, and whether his application for transfer can be considered or not in accordance with the prevailing rules. Released 5th January. Combined monthly list of January. Yes, next.
Wait, petition, lordship. Not for the petition. My lord, kindly sees my lord's last order date 21st of November.
State. Binoy Kumar Das and Amrita Tiwari. Nobody is there.
My lord, neither any report that has been submitted to at least my lord served to us.
Yeah.
এই দাদা
13. Where is your friend call for the state? Because I see the order that the state was directed to revert with the
Yes.
staff strength of the school.
Because my lord, my submission before your lordship was that though this lady was a single teacher, my lord, but 3 other teachers have joined in the upper primary selection process, and 2 other teachers have already opted. So 5 more teachers will be coming. So instruction of the state was very much required.
Give a phone call and come back. Let it remain in the list.
As your lordship.
Next. Not today.
But could it be a lordship's pleasure, my lord, to direct the state to file a report and serve it on me and come back? I'll indicate this order to my learned friend who is appealing for the state.
And appears on behalf of the state respondents. Stop. The DI, which place?
My lord.
Secondary education, such and such, is directed to file a report
Alright, it would
in terms of the direction passed by the court on 21st of
November
November 2025.
5.
Stop.
My lord, DI Paschim Medinipur.
Paschim Medinipur. Secondary education, Paschim Medinipur. Let the report be prepared and circulated
Grateful.
by 6th of January. Release the matter on 3rd.
Grateful.
13th January. Yes, next. Let this order be communicated to the learned advocate representing the state respondents.
Do that. My lord, item number 39, my lord, similar to 17, but there is a difference, my lord. Here, my lord, pursuant to the order of the coordinate bench, my lord, petitioner's counseling was conducted and petitioner was allotted a school. But because of pendency of the writ petition, official recommendation was not issued. My lord,
Pendency of which writ petition?
my lord, pendency of this writ petition. Petitioner was a job loser in 2019, 10, 11, 12. Petitioner, on that ground, my lord, petitioner was given a chance, my lord. If your lordship kindly sees this, my lord, it actually.
Declaration.
My lord, petitioner lost her job, my lord, in pursuant to Boishaki Bhattacharya. And my lord, petitioner was also a merit listed candidate in upper primary. But at the time of counseling, she did not appear, my lord. Thereafter, she filed a writ petition for recounseling. The coordinate bench directed you conduct counseling and keep the matter pending. My counseling was conducted and this letter was issued.
That means you have been recommended.
Officially, I have not received the recommendation letter.
Then where from did you get this?
My lord, after counseling, this was issued. A recommendation letter, my lord, is something else, my lord. I have been
Declaration
allotted a school.
as to selection of a school. That means the candidate has been found to be eligible for being appointed even after the counseling process. What is to be done?
Even the
Previous also
they were
eligible.
But they did not get any interim orders.
Right.
The interim order was to allow in the counseling subject to the availability of the vacancies.
Now the vacancy has also been identified.
It was called for counseling, school was allotted, but the recommendation was not issued.
Because of the pendency of the writ
and
petition.
because it was only for counseling.
Right. Now if the school which has been allotted still contains a vacancy, then let the petitioner join.
Still contains a
Because this is your submission. Acha. It has been submitted by the learned advocate representing the petitioner that in compliance of the direction passed by the court, the petitioner the petitioner was permitted to participate in the counseling process, and a school has been identified where there is matching vacancy for providing appointment to the petitioner. Stop. The formal recommendation letter has not been issued because of the pendency of the instant writ petition. Paragraph. As it copy of the communication of the School Service Commission regarding declaration as to selection of a school on attending the counseling session has been handed up in court today by the learned advocate representing the petitioner. Stop. The declaration was signed on the 11th of June 2025. Paragraph. Now, as it appears that a school with matching vacancy of the petitioner has been found to be available, accordingly, the commission is directed to issue the recommendation letter in respect of the petitioner for the school which has been selected for the petitioner on the day of counseling. Stop. Such recommendation letter shall be issued at the earliest, but positively within a fortnight will be all right. 3 weeks from the date of communication of this order. The writ petition stands disposed of.
My lord, only one thing, sir. Accordingly, the appointment letter will also be issued by the authorities. Otherwise,
Yes, the board will issue the appointment
no,
letter.
probably in upper primary money, it is the
Who is-
managing committee of the school who is issuing.
Managing committee of
My lord, let it be.
আচ্ছা তাহলে একটা লাইন লিখে দিন after the order of recommendation after issuance of the recommendation letter all authorities shall take necessary consequential steps in the matter in accordance with law.
Yes, deeply.
One thing my lord recorded in the last line that selected for the petitioner, but it was actually selected by the petitioner.
আচ্ছা selected by the petitioner.
Deeply.
Well, it's similar issue. Similar.
Last matter similar issue.
Similar issue. Mukti Vishwas, that is the
Dr. Patro, item 40, same order is being passed. All right.
I'm for the state law.
Same means the which
Yes,
one?
yes.
Same,
My lord, just previous matter. Previous matter.
not
I comment-
17-1.
No. But it is.
It will be 39.
39.
39. Same as 39.
Same as 30.
All right. Yes.
Great.
For the petitioner, same as 39, recommendation or the allotment of school is there, 11th of June, same day.
How many are there?
Only one.
One more?
আমাদের একটা আছে।
Beyond the list, there are several.
আমাদের তো
Many.
একটাই।
All right. All right.
Great, ma'am.
Yes, disposed.
Yes. Same as 39, my lord.
Same as 39, 11th of June.
Yes. Same date. They have made counting
right.
on the same.
Yes,
I'm
same.
for the state law.
All right. হয়ে গেল তো 42 হয়ে গেল তো ah
42. And read disposed of. 42.
disposed of.
No, what is the date next week?
It is disposed of. 43.
Grateful year.
My lord,
I am for the petition.
Where were you in the last matter? I
My lord,
didn't see you.
my lord, I
Item.
very sorry, my lord, I could
Which
not
item was
appear
that?
at the earlier matter.
Which item?
In 28, my lord, I was appearing.
I-
But
আঠাশ-
while I was coming, my lord, it
ঠিক
was
আছে 28 ওনার নামটা দিয়ে দেবেন তো 28
My lord, in 35.
না না এটা এনার
Wait.
কথা বলছি রঞ্জন সাহা
আরে 28 এ জোসেফ কি বলছেন?
না না he's speaking of something else. He's got
Yes,
separate
I
state.
know.
All right, yes, what is this?
Well, I am for the petitioner.
My lord,
What is it?
my lord, in this matter, my lord,
You are directed to submit a
my
report.
my lord, there was a dispute regarding the my lord certificate, pay certificate, which was submitted by the petitioner. My lord, subsequently we have found that it is wrong, and my lord, he is entitled. My lord, kindly take please take it into at 2 p.m. My lord, I shall come with that report.
You
Or
have
not
that,
today.
You have that report with
Yes,
you?
yes. In my brief, my lord.
All
it
right, then
is.
not today, tomorrow.
Not today, tomorrow.
এইটা কালকে আর্জেন্ট মোশনে দিয়ে দেবেন তো
He is entitled now, my lord. As his lordship is a
Urgent motion.
last word. ঠিক আছে?
Give a copy in advance to
Yes,
him
yes,
so that-
I shall give him. ঠিক আছে।
I'm for the petitioner, Miller. Miller, earlier occasion, order was passed to serve notice to the government leader, and I have served notice.
Who is appearing for the state?
Mr. Mahato,
Which Mahato? So many Mahatos are there.
Mr. Lalmohan Mahato and Mr. SP Mahato.
Lal Mohan Mahato.
Sorry, Lolit Mohan Mahato.
He was here some time back. Yes, and who is assisting Mr. Mahato?
Mr. PB Mahato.
Yes, Prashanto Bihari Mahato. Where? Call him.
Next matter, I have the next matter.
Yeah, all right, you call him. Give a phone call first. Yes.
Question was about the state to produce the vacancy list.
Did you communicate this order
Yes,
to Mr. Mahato?
Yes, my lord, and already I have communicated about the direction discussed earlier occasion.
All right, let Mr. Mahato come. Let us see.
Grateful, my lord.
All right, 45.
45 I am for
My lord, I am for the state. Before my learned friend starts, my lord, your lordship directed the DI of schools, my lord, to file a report. Now, my lord, I have taken instruction, my lord, that DI of schools, my lord, has undergone and surgery. If your lordship grants some time, my lord, so that I can come back with the report.
Well, may I?
45 to
45, I am for the private respondent. But it is mainly challenging the removal of TIC. The teacher says that he was TIC.
You are the TIC?
No,
No.
I'm one of the assistant teacher. Against me, several allegations are there. Respond number 10. Only kindly see this removal from TIC has happened in terms of the direction passed by the DM. Kindly see the allegations. The direction, why it has been done. Kindly see for, kindly see for once
52
why it has been done.
Previous matter, order was passed by this honorable court, page 52.
For his resumption of
Prior to that, you also can
now,
see.
my lord, I am
What
compelled
was
to
the order
say,
passed by this
I
court?
am compelled to say, in the midday meal scheme, he has conducted ranked illegality. Kindly see the DM's order for once.
Yeah, Pradeep.
As per the instruction of the
Learned
DM, he
advocate
has been.
presenting the state respondents. Seeks extension of time to file the affidavit. How soon can the affidavit come?
Report.
Report. All right, report.
At least 2 weeks. Let it be up.
After the vacation?
Hey, আমার নামটা দে, number 10.
13th of January.
May I take back this?
Yes, please take back.
I've called Mr. Mahato, but he's not picking up the call.
All right.
I'm again calling him.
Yes, next.
46, my lord, I am for the petitioner. This matter relates to, my lord, interest on the delayed payment of, my lord, ROPA 2019, but petitioner was late. Petitioner filed after 3 years. Well, now, last occasion, your lordship, my lord, directed the petitioner to be present, but he do not want to proceed now because he is suffering from congest. He has given me that very 5% interest, and that is why he's not interested.
Had he come, I would have sent him to jail. That is the reason he has not come.
The next matter, petitioner has come, but
I follow. The court understands what happens.
no, he's giving
Yes,
that.
yes, very well, not pressed. Next.
Forty-seven, my lord, the same order. But I don't know, my lord, here also, my lord, petitioner was late. In 2021, he received the amount, June 2021. And he's filed the case on October 2025.
Why?
My lord, petitioner, according to petitioner, he was ill. He was totally alone. Yes.
He was ill.
Yes.
Right.
He is not physically well. Your lordship can, my lord, ascertain from.
Item number 10.
48, I am for the petition.
Yes.
The-
My lord, here is the vacancy report.
My application was recommended by the DI to the School Service Commission, but I have my lord, handed over my lord, the last occasion that the School Service Commission intimated there is a low rank of the low students my lord, in the school. But the particular subject there, you will also kindly see the last order.
Now, what is the
DI
vacancy position?
DI Kolkata is a party I have served upon the DI Kolkata. There is no teachers my lord, in the particular
The
subject.
number of sanctioned posts is 12 with 7 teachers at present. 100 students. What will the teacher do over there? Huh?
কত স্টুডেন্ট আছে কত টিচার
100 students.
Teachers
7 teachers.
7 teacher but no there is no geography teacher.
There is no student.
100 teacher.
There is no student. What will the teacher do over there?
Now I am malady. I have instruction malady, specifically not malady written instruction. Now the vacancy has been reported to the second SLST, particular my subject. Malady, on hand malady, they communicated that there is a low student. Now the vacancy has been reported. This is malady. No. Geography teacher is required.
A teacher is required. There is no geography teacher I can see. There is no geography teacher. How does the school function without these teachers?
There are no students, madam.
That is the reason.
There are 3 groups. One language group, social science group, and science group. But a history teacher can also be the geography.
No.
Class 5 to 8, 5 to 8, and 10 marks.
High school.
There is 5 students reading in class 8.
What is the use of keeping a teacher by paying so much of money? Has any audit been conducted to ascertain as to how many schools are there with the proper pupil-teacher ratio?
Board can assist you. We are only the recommending.
Then you all recommend only after seeing the vacancy list.
As per rules, recommend where the teacher ratio
Is low. I understand. So you get to know. So nothing can be done. If it is reported and if it goes in a regular way, then it is all right. Otherwise, how can the court
Another
ask a
vacancy,
direction?
let them malady DI Kolkata to malady submit a report finding out the another vacancy because the
It cannot be done.
no malady I am my application transfer application has been recommended to the School Service Commission on medical reason. Malady the honorable division man malady clarified that her application should be considered malady on medical ground.
Then in some other school where there is proper vacancy, it has to be given.
জানাতে হবে DI Kolkata. DI Kolkata malady was directed to file a report. Now particular smaller schools he has submitted the vacancy report.
Yes.
The other schools malady maybe there is a vacancy. I'll direct the DI Kolkata to find out the vacancy malady.
Please come.
Kindly direct the commission exercise the power conferred by the 4.2D, where an application is made under medical ground, suitable vacancies found by the commission, commission shall give another opportunity. So the commission kindly direct the commission, secretary of the commission, to give a hearing, and if there is any suitable vacancy. Verification from the DI or the board.
Vacancy statement can be reported by the DI Kolkata because I am now in Dakshin Dinajpur. My residence in Kolkata. Malady
লিখুন তো যে the vacancy statement of the school forwarded by the teacher in charge on 8th December 2025 has been placed in court. Stuff. It appears that the pupil-teacher ratio in the subject school is extremely low, for which the recommendation could not be issued for transfer in the said school. Stop paragraph. The petitioner seeks transfer on medical ground. Stop. She is currently in Uttar Dokhin
Dokhin
Dinajpur
And
and
my lord,
she,
her husband is living UK. My lord, the very difficulty, my lord, she is alone.
it's better you go to UK. Acha. Dokhin Dinajpur and she seeks transfer in Kolkata.
Dinajpur.
Stop. Next. The district inspector of schools is directed to
The rules provide.
the district inspector of schools is directed to produce the vacancy statement. Acha, matching vacancy statement where the petitioner may be accommodated in the district of Kolkata. Stop. Released 13th of January. State respondents, have you followed what is to be done? Inquire it and produce the statement before the court on the next date.
Including the PPT. Next day.
13th of January 2026. আচ্ছা এই মিস্টার মাহাতো এসছে ওনাকে ডাকুন which item was yours?
Yes.
44.
44, my lord.
Uh-huh.
Regarding vacancy list, state was directed to.
Is the list there with you, Mr. Mahato? You obtain the vacancy list. There is already an order. Why is your junior not keeping track of matters? It is only the senior's work.
I was in court number 10.
It is all right. Please come. The learned advocate representing the state is not ready with proper instruction. Stop. Let instruction in terms of the direction passed by the court on 25th November 2025 be produced before this court on the adjourned date. Released on 13th.
Item number 49. Your Lordship, Your Lordship, I'd like to take a leave of this court for filing an urgent matter. It is regarding an SSC matter where Supreme Court had directed in the year 2016 that untainted teachers can continue with their jobs till 31st December, utilizing the rule laid down by the Supreme Court. And now, Lord, after 31st December, we do not know as to what will happen to us or our jobs. So kindly,
What is your prayer?
prayer is to look after the matter, Your Lordship.
Look after the matter means? What does look after the matter mean?
Kindly hear me once.
Yes, I'll hear you. But why have you come now? This is not the time to mention. Where from are you coming? Are you a practitioner, regular practitioner of this court? Are you? Is mentioning allowed at this point of time?
Lord, I was told that after a break, there's a
Who told you? Somebody must have told you. Who told you? Come tomorrow morning. All right? Yes. Yes.
The petitioner,
The staff yet to receive terminal benefit.
is a group D staff, yes.
Yet to receive terminal benefit. Why? Give a copy to him.
I have seen, Melody.
You've seen? What is the
DI has
instruction?
requested the school to forward. Online application has been submitted. Now,
When?
as per the objections, my lord, the manual file has not yet been received by the DI. That is I have instructions also revealed. You know, so direct the DI, my lord, the school, my lord, direct the school to forward the pension papers to the DI.
You retired on 29th of February 24 and you submitted your application only on 3rd of January 24. Why? You are required to submit your application nearly 18 months back.
The group D staff, my lord, I don't know, my lord.
And then you will come seeking interest on account of the delayed payment of terminal
Of the
dues.
institution should, my lord, assist, my lord, the group D staff, he doesn't know anything.
He knows everything.
Page 16, I will see, my lord, the online application I have.
Now the group D staff is better acquainted than the class 1 officers.
And there was no complaint regarding overdrawn or allegations, nothing.
All those comes later on. Objection by the school in July. School returned back to the petitioner in August. Then the applicant forwarded his pension file to the head of the institution in September. All 1 month, 2 months difference. The school did not forward the pension paper to the office. Please come. Peruse the report forwarded by the District Inspector of Schools, Secondary Education, South 24 Parganas, signed on 19th of November 2025. Stop. It appears therefrom that the petitioner, comma, a class 4 staff within bracket peon, comma, retired from service on 29th February 2024, but his pension file is yet to be made ready. Stop. The records reveal that the petitioner submitted his pension application with other papers to the school authority on 3rd January 2024, and the school forwarded the same to the office of the DI. Forwarded soft copy of the same to the office of the DI on 14th of June 2024. Certain objection was raised and the file was returned back to the school on 13th of July 24. Stop. The school authority returned back to the petitioner on 1st August 24 and the petitioner forwarded the pension file to the head of the institution on 4th of September 2025. Stop. Till date, the school authority did not resubmit the pension papers of the petitioner to the office of the DI. Stop. Paragraph. Request was sent by the DI to submit hard copy of the pension papers of the petitioner to the school by a communicating memo dated 18th of November 2025. Paragraph. From the sequence of events mentioned herein above, it appears that the movement of the pension file of the petitioner initiated practically after his retirement. Stop. The same ought to have been done prior to the retirement of an employee. Stop. The school ought to have been more vigilant and made the pension file of the employee ready well in advance of the date of superannuation. Stop. Paragraph. As the employee has retired in February 2024, accordingly, the District Inspector of Schools 2024, and it is high time that the terminal benefits should be released in his favor. Stop. The District Inspector, as accordingly, accordingly, the District Inspector of Schools is directed to follow up the matter with the school authority for making the pension file of the petitioner ready. Stop. All steps shall be taken to ensure that the terminal dues of the petitioner are released at the earliest, but positively by 31st March 2026. Read petition disposed.
The one directions
Section
upon the
related.
DPPG on headline 9
the District Inspector of Schools shall also forward all papers to the Director of Pension, Provident Fund and Group Insurance for issuance of PPO in favor of the petitioner. তারপরে বলবেন যে shall ensure that the retirement dues is released within 31st. ঠিক আছে, এই লাইন ডিপিপিজি কে আগে দেবেন, তারপরে আউটার লেটার দেবেন. Yes.
Well, I am for the petition. Well, kindly see the last order passed by your lordship.
Yes.
The petitioners, my lords, after taking the permission from the managing committee, he enhances qualification.
1 minute. How is this matter different from Utpal Kanti Karan?
I also have Sanjay Mondal, your lordship.
Lordship, first of all,
Sanjay
Passed the
Mondal
order.
is there.
Your lordship passed the order, madam.
Yes.
okay, here, Lordship, the petitioner did not take any prior permission. He has applied before managing committee, but the search has never been forwarded to the DI.
Is it his fault? Then
But thing is that in such the school authority is also not present.
Doesn't matter.
But
Is it the fault of the petitioner if the school does not forward it to the DI's office?
Prashant, kindly come to the instruction option.
Yes, what does it say?
Prior permission is required. Or,
That is what you are submitting.
but or the resolution of the managing committee to be forwarded when the managing committee has taken any decision. But neither such has been forwarded by the petitioner.
Tell me, is this the fault of the petitioner? Why will the petitioner not get the benefit?
GI has no law. Prior permission is very much required in that case. And the Upalkanti is that it's the, after he has get the appointment in the honors graduate, after that he did the
Please come. The petitioner seeks higher scale of pay on enhancement of his educational qualification. Is there any rejection?
Yes, madam.
Yes.
Page
Page 98, madam.
His prayer stood rejected by the District Inspector of Schools, Secondary Education, Purva Bardhaman, with a communicating order dated 31st December 2024. On the ground that the petitioner did not obtain any prior permission of the concerned District Inspector of Schools. Stop. (593) was taken up into consideration, isn't it, Geo?
Yes, ma'am. Paragraph number 179, larger bench, madam.
Larger bench.
Yes, ma'am.
Acha.
Set aside the 593.
That has been set aside.
Madam.
Geo 593 is 6 নম্বর থেকে Geo 593 AC within bracket B dated 21st November 2007 has been relied upon for rejecting the claim of the petitioner. Stop. The applicability of the aforesaid government order was considered by the special bench in the matter of Utpal Kanti Karan and others versus State of West Bengal and others, reported in 2024 SCC Online Cal 1274, wherein the court was pleased to set aside the said government order. Stuff. The petitioner obtained the prior permission of the school where he was teaching prior to
Take admission.
taking admission in the which course?
MSc.
Master degree course. ঠিক আছে? Stop. According to the DI, the resolution of the managing committee was not forwarded to the District Inspector of Schools. Stop. Paragraph. Whether non-forwarding of the resolution of the managing committee according prior permission to a teacher to enhance his educational qualification will disentitle the teacher to receive higher scale of pay was considered by the court in WPA 29958 of 2016 in the matter of Narayan Chandra Borai versus the state of West Bengal and others. And order was passed by the court on 19th March 2024, holding that the obligation of a teacher comes to an end the moment the teacher applies before the managing committee of the school for obtaining prior permission for enhancement of the educational qualification. Stop. Thereafter, it is the obligation of the managing committee to forward such resolution to the concerned DI for obtaining prior permission. Stop. Paragraph. The court in WPA 21965 of 2025, Sanjay Mondal versus the state of West Bengal and others, passed order on 14th November 2025 in similar set of facts directing the concerned DI to take steps for grant of higher scale of pay. Paragraph. As it appears that the facts of the present case are similar to the facts of the case of Sanjay Mondal within bracket Supra, comma. The instant writ petition is also disposed of in the same lines. Stop. The District Inspector of Schools, Secondary Education, Purva Bardhaman, is directed to take necessary steps for grant of higher scale of pay to the petitioner in accordance with the relevant rules. At the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. The impugned order of rejection dated 31st December 2024 stands set aside. All consequential benefit shall be released in favor of the petitioner without any further delay.
Good.
Instruction written with the records.
My lord, I for the petitioner. The matter relates to, my lord, delayed payment of interest. Here, my lord, your lordship's query, my lord, is a died in harness case. And your lordship, my lord, the date of death of the employee, my lord, on 26 November 2019, and the PPO issued on 1st December 2022. Your lordship has passed one order from the due date. My lord, that is why, my lord, I am relying on.
I got the instruction.
Please give.
Due to lack of document.
Please give. Forward it. The teacher expired.
On 26th November 2019. Now,
Right.
para 3, your lordship, that it was submitted on 22nd July 2020. Well, within 6 months.
So, yes, it was submitted.
More or less 6-7 months.
6-7 months. And then it went up to the
Well, authority to getting well at past service continuation.
It took time.
Yes.
So, what can be done?
Well, for that, well, para 4, para 5.
19, and then it was 22.
Yes.
There is not much delay.
Well, from 2020 to 2022. 2020 to 2022.
18 months is the usual time for making the pension file ready.
That is for the no, not 18 now. Now it is the digitally, it is only 1 year.
1 year, 12 months.
6
now
months
it
before
has.
retirement, it has to be submitted. 6
No,
months.
Not 6 months. It takes.
No, my lord, it was 6 months. From 2017,
Hmm.
it is cut short down to 1 year before the retirement. He should be given notice, and before 6 months, it has to be e-pension file has to be submitted.
All right. Now this teacher died in harness.
Yes.
So the papers were not there. Obviously, it could
Papers
not
are
have
there
been.
in the school. Well, in the died in earnest case, there is no intentional delay on the part of the employee concerned because he already
Passed
expired.
away.
Naturally, it is up to the school authority to do.
Yeah.
My lord, admittedly, 22nd July 2020, my lord, it was submitted. So, my lord, on and from 2020, petitioners has no role to, my lord, get this, my lord, all these files from this office to pillar to post, he cannot, my lord, run.
That is all right. But then
and the rule says, my lord, it is due and payable from the following the date of death.
following the date of death,
yes, that sometimes should be made.
superannuation is
Yes,
all right.
Yes.
Candidate
Yes, yes.
superannuates, it's
Yes,
all
yes,
right.
I
Death, certainly it cannot be.
cannot be.
So you have to give that much of time.
So on and from, my lord, July or August 2020, I am entitled. That is my only submission.
It was submitted in July. How
Yes.
can you get it 6 months if you take
Depends,
it?
sir, within 7 days, it is now, my lord, getting the benefits.
No, this 10 years
Yes,
CS benefit had to be given.
That
Ajay,
is
please
given
come.
by the PSA Pension Sanctioning Authority. And that is, all the records are now digital, my lord.
The wife of the petitioner was serving. No, serving na. Wife of the petitioner, who was a teacher, died in harness on teacher of an approved headmistress. Was an approved headmistress of a school who died in harness on 26 November 2019. Stop. The e-pension payment order has been issued on 1st December 2022 and payment actually stood disbursed on 19th December 2022. Stop. The petitioner seeks interest on account of delayed payment of the terminal dues. Stop. The District Inspector of Schools, Secondary Education, Purva Bardhaman, has forwarded a report wherefrom it appears that the pension file of the teacher was initiated and submitted online to the head of the institution on 17th July 2020 and hard copy submitted on 22nd July 2020. Stop. For providing the benefit of past continuous service of the for providing post facto approval of the past continuous service of the teacher for CAS benefit, comma, there has been delay the post facto approval of the CAS benefit was accorded by the Deputy Secretary, Government of West Bengal only on 21st September 2022, and thereafter the PPO was issued on 1st December 2022. The paragraph there, the DI has mentioned that without the post facto approval of the CAS benefit, the pension sanctioning authority was unable to proceed with the pension file of the petitioner. Paragraph. As the teacher died in harness, accordingly, the pension file of the her pension file was not made ready earlier. The process for initiating the pension file started only after the death of the employee. On a perusal of the report forwarded by the District Inspector of Schools, the court is of the opinion that this is not a fit case for directing the authority for grant of interest on account of delayed payment of the terminal dues. The writ petition accordingly fails and is hereby dismissed.
On and from 20 to 22, my lord, respondent has taken time.
Next.
$52 also, my lord, died in harness. Report আছে? 28th December 2022, my lord, died in harness. And my lord, PPO issued on 2nd November 2023.
Not even a year.
Yes.
Less than a year.
Yes.
So, what is the instruction? Why? Who has not given you the instruction? Which DI? How can you get the instruction within 1 week? Because you sought for instruction and you did not get it. Bring the instruction. Please come. The petitioner seeks interest on account of the delayed payment of the terminal dues in favor of her husband, who expired while in service on 28th December 2022. It appears that PPO was issued on 2nd November 2023. The paragraph there, the District Inspector of Schools, Secondary Education, Bankura, is directed to forward a report explaining the delay in issuance of the PPO. Released 5th January 2026.
Great.
My lord, item number 53. In this matter, my senior Mr. Dibyendu Chatterjee is engaged before another court, my lord, praying for not today.
Why don't you proceed?
My lord, as per our instruction, he will do this matter, my lord. That is why. Praying for just one, not today, my lord.
Where is the advocate on record?
Uh, Is it Mainak Singh Verma?
You are questioning the court.
No, my lord,
the
no,
advocate
no.
on record.
I'm not directly engaged in this matter. That is why, my lord. Pardon.
What is the matter? Who is for the respondents?
For the respondent number 8.
Respondent number 8. So many respondents.
Private respondent.
Group of private respondents. How many petitioners are there? 25. What is the issue? What is the issue? Prayer. What is the prayer?
Prayer is rather defective.
Defective.
Yes, because they have prayed for a direction upon the Board of Primary Education to allow the petitioners in the
Primary. Is this a primary?
No, but school service
School service
commission
commission.
authority.
It is upper primary mentioned.
You kindly see page 33.
Yes. West Bengal Board of Primary Education. Where is the council? Why is the SCC coming in then?
No, it is with regard to SCC.
Then primary must be wrong.
Yes, that is maybe a result of copy paste.
Maybe. Appointment. I see they are commanding to give appointment to the petitioners as assistant teacher of upper primary level. Recruitment process of 2016.
Well, I am appearing on behalf of the respondent number 13, my lord. My lord, I think, my lord, the respondent number 13 ought to expand. Why? My lord, this says respondent number 13 is age bar, overage. I am showing just one page, my lord. That is
Wait, the petitioner is not here.
Oh, sorry.
My lord.
Edit commanding to call the petitioners for counseling process. But what is the process? What is the stage?
The stage is the final expired.
September.
Yes.
Ah.
And they are now paying to participate in a personality test with regard to this people
Long back.
That is the reason repeated adjournments are sought.
No, my lord.
No.
And not only that, on factual aspect also that is wrong.
How many court fees? Shailesh, please check. How many court fees paid?
Okay. 25 petitions, my lord.
This is the respondent's Wakalatnama has come in. Petitioner, only one court fees paid.
My lord.
Please come. The instant writ petition has been filed by 25 petitioners. Look at the cost title. How it has been typed and printed, all caps, till 21. And thereafter, addition of parties. So they have come in small letters. Achha, 25 petitioners by submitting only one court fees. Stop. Leave is granted to the advocate on record of the petitioners to submit the deficit court fees prior to the adjourned date, released on 5th January 2026.
My lord.
Record appearances of private respondents, state, commission, everybody.
Thank you.
Yes, he is engaged. Yes, so what is to be done? Passover. What is your prayer?
No, this is a second SLST matter.
Second SLST matter. Why are you so special?
In 2000,
You come this side. Otherwise, they are not getting. You take this microphone. Yes.
my lord, in 2013,
Hmm.
I was appointed in 12th in person to the recruitment process to 12th RLST. Thereafter, I was continuing my service up to 2019, and I appeared in 2016 recruitment process, and I was a successful candidate, and I was appointed in 2019. But thereafter, I apply in Utsashi portal, and I was transferred in 2021. And thereafter, I appeared in the recruitment process of assistant headmaster, which is a separate. I think because in my lord, I want to bring the notification to draw your attention at page number 26, annexure P5. 26 P5.
Yes.
Para 2. In para 2, headmaster or headmistress or teacher in charge, as the case may be, as directed by the school authority after receiving of prior permission from the district inspector of schools secondary education for filing up of the post of assistant headmaster, assistant headmistress shall notify and collect applications of such approval and willing teachers of his or her institution who are graduates with honors, including special honors or holding master
No,
degree.
what happened?
Thereafter, just now, 2 years course and having 5 years teaching experience in a junior high school, secondary institution. This is my crucial point. I want to apply for being appointed as the assistant headmaster, I have to comply 5 years teaching experience. My teaching experience was calculated on the valid service.
What? Your?
My teaching experience for 5 years was calculated at the time of being appointed as an assistant headmaster on the basis of my valid recruitment. From since I was appointed in 2013 in person to the 12th RLST. That is why I was a valid teacher up to as I was discharging my duty up to 2019. Thereafter, in 2016, I was appointed in the 2016 panel, which has been already cancelled. Therefore, my humble request before your lordships, my assistant headmaster recruitment process based upon my valid service.
Yes.
Not on the.
What is your prayer?
Oh, I have been issued the letter to go back to my previous service. But it is not as per constitution. It has no validity.
Implementation of an order passed by the Honorable
He wants repatriation.
Repatriation, but my lord, he has been repatriated to his original place of posting
And not as the head.
of the order passed by the Honorable
Not as the headmaster.
That yes,
He wants to be repatriated as the headmaster.
in the post of assistant.
No, I have been repatriated to the previous original service, but it is, I think it is unconstitutional.
Unconstitutional.
My right has been I have been aggrieved by that order.
By that order, where is that order?
Order I have annexed my annex of P12 page 39. No, madam. Wait, this is my representation. Answer P12, my lord.
Yes. Has the time period expired for you to join?
Yes,
What
expired.
is it has expired?
Yes, expired. I have also joined to that in person to yes, without prejudice my rights and
All right.
contention. I have joined, my lord, to save my life.
Yes, certainly.
But my rights has not been snatched, my lord.
Yes, the commission. Recommendation is letter is by the commission. He was serving in the post of headmaster. You recommend him as assistant teacher. No, or whatever. Even if it is assistant headmaster, now he is the assistant teacher. So the grade changes.
Yes, madam.
Then you will recommend him to the post of a peon.
Yes.
Are you sending the teachers back to the same school? You are not. You send him to somewhere else.
That the state has to provide us with. We do not know which back to send.
You do not know anything. You recommend a teacher to the post of a peon. That is your work.
Whatever has been provided, we have recommended to a post of a teacher only. We have not. The difficulty for us is the assistant headmaster's post, whether he, first of all, we do not know what way, whether he was a property assistant headmaster or what kind of the way he was.
Without knowing anything, you do everything.
Available with us, but has taken up other matters in similar way. We have done that thing also.
No, this is something different.
Yes.
This
yes.
is not one of those regular matters which are taken up where the teachers are repatriated to any school you feel like.
Grateful.
The court has not interfered in any of the matters. But here he is an assistant teacher, headmaster.
Yes, ma'am.
And you recommended him to somewhere else. Find out what is to be done.
Yes, my lord.
Please do.
Yes, madam.
The petitioner. The petitioner has been repatriated. Now, the petitioner was serving in the post of assistant headmaster. Headmaster in a school when his service, when he took up the job of assistant teacher, being successful in the first SLST, 2016. Stop.
Prior to that,
After the 2016 selection process stood cancelled by the order of the Honorable Supreme Court, the petitioner has been repatriated in terms of the Supreme Court's order, not in terms, in accordance with the Supreme Court's order, to a school in the post of assistant teacher. Stop. He is aggrieved by the same. Stop. He submits that he ought to be appointed in the post of assistant headmaster. Stop. The learned advocates representing the state and the commission are directed to revert with instruction. Stop. Next. Be it recorded that in terms of the letter of recommendation issued by the West Bengal School Service Commission, the petitioner has joined the school without prejudice to his rights and contentions. Stop. 5th of January. 6th of January.
grateful deeply.
Yes.
My lord, here, my lord, the case is, my lord, petitioner was initially appointed as a part-time teacher. My lord,
Is this also a SLST matter?
No.
Or separate? The respondents are there?
Yes.
All right.
My lord, petitioner was appointed as a part-time teacher in a school. My lord, subsequently in 2014, petitioner left the job and petitioner has got an appointment in a permanent post in 12th Dara list and he got. Thereafter, my lord, what happened? Some of the colleagues of the petitioners in that school filed a writ petition that you give me equal pay for equal work because we are serving and doing similar duties. My lord, the single bench passed an order, said that no, there should be an equal pay for equal work.
an appeal was preferred by the state, my lord, and it was modified. The division bench modified the order to the extent that up to from 2010 to 2030, they will get this equal status of basic pay, equal pay for equal work. And SLP was preferred. My lord, in the SLP, it was dismissed, but Supreme Court made an important observation that all similarly situated candidates should be given this benefit. Now, my lord, I worked till 2014. From 2010 to 2014, I worked. I won the arrears from 2010 to 2014. My lord,
Arrears means the enhanced amount.
enhanced amount. My lord.
All right. Did you make any
Yes,
representation?
yes, I made one representation.
That is pending.
Yes, my lord.
Oh, you want consideration? What is, did you
64
get any instruction? No.
Consideration. 64 এর আছে কনসিডারেশনটা বলি
Please come.
রিপ্রেজেন্টেশনটা কনসিডারেশন বলি
The petitioner
টাইম লিমিট
seeks payment of arrears salaries in terms of the judgment passed by the Honorable Division Bench of this court on 3rd September 2020 in Mat 1221 of 2019 within brackets State of West Bengal and others versus Anirban Ghosh and others, and the order passed by the Honorable Supreme Court in special leave to appeal within brackets civil number 14355/2021 and page 64, page 11, 2809/2021. What is the transfer
My lord,
petition?
two matters were taken up together, my lord. The main order is this, my lord. At page
59.
59. Relevant is 60. Both the matters were taken up together. A transfer petition from the court.
Transfer petition orders appears on page number 61. So petition cannot correction. Same,
Acha.
was dismissed.
2021
Same.
and the order passed in the transfer petitions within brackets C number 1288-1297/2022. Stop. It appears that a representation through the learned advocate was served upon the Commissioner of School Education in August 2025. But there is no response from the authority till date. And is the commissioner the competent authority
Yes,
to
my
look
lord.
into it? Show me.
My lord, because salaries, unless commissioner passes an order, DI cannot. My lord.
The Secretary School Education Department to decide the claim. Secretary, it's the Secretary School Education Department. The direction has been passed. It appears. Revision bench passed order, page 57.
Yes, that direction that these petitioners should be given equal pay for equal work was upon the secretary. Thereafter, my lord, executing authority is the Commissioner of School Education, my lord. I can also have, give a fresh representation to the secretary also.
দুজনকে দিয়ে দেবো।
As it appears that the representation filed on behalf of the petitioner is pending consideration before the Commissioner of School Education. Accordingly, the instant writ petition stands disposed of by directing the aforesaid authority, being the respondent number 2 herein, to take a decision on the petitioner's representation strictly in line with the judgments mentioned herein above. After giving reasonable opportunity of hearing to all the necessary parties, at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner immediately thereafter. Step. If the prayer of the petitioner is allowed, comma, the necessary consequential steps shall be taken without any further delay. Stop. Learned advocate for the petitioner is directed to forward a copy of the representation along with all other supporting documents to the aforesaid respondent at the time of communicating the order of the court. Disposed. Service is taken on
Okay.
record.
I am for the petition.
ঠিক আছে দিন যে জাজমেন্টস গুলো আছে হ্যাঁ
But I shall be but I made 16 and 25, which was
comparative
yes,
chart.
yes.
All right.
Because may I begin with this chart itself because that will give it's I made it it's complete neutral chart, not for whether for 25 or whatever is there. If Lordship before seeing in detail, if Lordship kindly take the next page, the crux of it, if I begin with that, the main differences, the 6. The written examination, earlier it was 55%. Now there is a 5 marks more, 60. The non-written component, earlier it was more, 45%. Now it has become 40. Now this maximum advantage from academics, this I will show from the first page itself. Now one interesting aspect, interview shortlisting for 100. Earlier it used to be calling 140.
Yes.
Now it is 160. Now Lordship kindly take the first page itself. First 55-60 I have already said. Now another major change is in the academic qualification. Earlier the marking was 35 in 2016. Now that has been reduced to 10. Now, prior teaching experience, earlier it was nil. Now it is 10, maximum 10 marks. Now personality test interview, earlier it was 10, now also 10, same. The lecture demonstration, earlier it was not there, now it is there. So if Lordship make it a two broad category of written and non-written component, Lordship will see that in the written component, there is a hike. Because why I want to little emphasis on the written, because written is a completely level playing field. And the non-written is something whatever someone has done past, whether academically and others. Now regarding this, kindly see, my lord, Roman 3, the which were the things which were there in 16. In 16, my lord, there were 3 buckets, like 25. But that buckets was supposed to be filled up by Madhyamik, then higher secondary, then graduation, B.Ed, and total was 35. Now, if Lordship kindly compare it, next page. This is not sorry, that is not next page, because there that I placed it is not here. Now it is only 10 marks, 3 buckets, and based on it's a graduation or post graduation, whichever is higher. So a major shift is that Madhyamik, higher secondary, and the marking for the B.Ed which were in all out, which were there in 16. That's the major shift. So therefore, that 35 marks was there. Now it has come down to 10. Prior teaching experience, that I need not say. Now, based on that, if Lordship kindly take the Roman 7, that what I intended to submit. First is under the 16 rules, written examination carried 55 marks, under the 25, 60 marks. So for a fresher, the most powerful component is the written test. But that's a general statement. So this is stronger than under the 16 rule. Why I was trying to, my lord, also focus on this, because their entire focus is on somehow disturbing the equality by 10, because regarding educational qualifications others, this is not the grievance that they have agitated, though I have given whatever is the plus minuses or the changes, but their grievance is on that. Now if Lordship look at that grievance, that today you don't get 10 because you don't have experience, because you are a fresher, one immediate reply could be, yes, you don't get that, but you also have 5 more if you are a better student because of the competition. That's a written marks. Just I would say, if someone says that, there is a possibility of the opposite way of looking it also. Now, non-written marks have actually reduced. Their under 16 rules, non-written components total 45 marks, academic 35, and personality 10. Under 25, this non-written components totally now only 40 marks, educational 10, experience 10, interview 10, and lecture demonstration 10. So this is, I would say, the major change. Now, 2025 rules do not increase discretion or arbitrariness. That I tend to say that it's not that interview marks is increased, where a subjective satisfactions of someone, or there is a possibility of arbitrariness, that is not there. Interviews, it remains same. C, experience marks are strictly capped at 10%. This part I am not making submission because this I already made submission. Now D, freshers compete on more written centric model, which I was trying to say that the non-written component got reduced little and written component got increased little. So therefore it is more. Now E is that shortlisting part, that now because of 100 it becomes 160. So chances
of being shortlisted increases.
So therefore, if a question is put to me, is it different? I would say yes, substantially 25 rules are different. It's not identical at all. But that substantial difference, if I try to look at from a neutral point of view, is towards, the answer is F. I've just put it in writing, F. The classification is valid under Article 14 if there is Roman 1, an intelligible differentia, and number 2, a rational nexus with the object sought to be achieved. Now, intelligible differentia, the candidates with teaching experience form a distinct class from freshers. So therefore, this is clear. They are different. Now, question is whether nexus, the nexus part, teaching experience improves classroom management and pedagogical skills are direct link to the object of selecting effective teachers. But that's it would be very difficult to prove it, but that's the
admittedly experience matters.
Yes, but that's I'm saying that for that I may not be able to prove by any tangible thing, but that's something which most of us, we recognize it. Now both limbs are satisfied, and then I just put it that the 2025 rules are not harsh to freshers. The written examination has become more dominant. Non-written component has been reduced, and the experience criteria is strictly capped at 10. The same ceiling as educational qualification can be entirely neutralized by performing well in the written exam. That's a stiffer part for the freshers, that you have to be better students, not everyone. The interview shortlisting ratio has been widened. So therefore, a better opportunity to reach the interview stage. So that's the plus for the freshers. So classification satisfy both the limbs, that's the nexus part and the intelligible differentia. And consequently, the allocation of 10 marks of prior teaching experience under 25 rules, that was my respectful submission. That so therefore, one sentence, yes, it is different. Substantial difference is there, but that difference is, I would say, tweak, which I would say gives more importance to experience, which can be said to be synonymously a life skill and more intelligent, better students. Well, there was one specific query. There was a specific query by your lordship. It was not to me. There was a specific query to Mr. Mithro. Lordships made the query from the Honorable Supreme Court, specific directions that it will not give them any advantage. Well, I was reading that, so I thought there was an interpretations possible. So I just thought that I should make that submissions. 3-4 pages. একটু দিয়ে দিন এটা মতো পেজটা বলবে। দেখে দাও, দেখে দাও।
রাহুলের অপোজিশন 4টে আছে একসাথে। একটা
না,
এটা না, মানে ভলিউমে করে ফাইল করতে হয়। দিস ওয়ান পুরোটাই।
এটাই। হ্যাঁ, পেজ 229টা দেখে নিন, যে ভলিউমটা 229। কোন ভলিউমে আছে 229টা? ভলিউমটা অ্যাকচুয়ালি আমি সফট কপিতে ইউজ করছি, তো আমার কাছে since I am using the entire PDF copy, for me it is
easier.
No, not easier. It is difficult because, in fact, there was a thing. This I am seeing in a one-dimensional less. When we touch this book, we are in the 3 dimension, and I think connection with the memory and the brain is much better. I say that in the entire PDF, I don't have a volume, so that's why I was trying to understand. The page number is 229.
Yes.
And Lordship's query was on page 230, 17-4 order. Because this, I have observed that there are 2-3 occasions Lordship wanted to know this. That we clarify, Lordship has got, we clarify that this order shall not be read as conferring any special right or advantage on the aforesaid teachers insofar as fresh recruitment process is concerned. Therefore, this 17-4 order clarifies that it cannot give any special advantage. So I was, because apparently it is very much a negative point if I appear for these candidates who appeared. So I was trying to understand what exactly the order says so. The order basically, may I just first say, thereafter I will show. After this Boishaki judgment, state filed an MA, saying that 1, 2, 3, 4 reasons kindly allow the assistant teachers to continue. Just only for that. And that was the prayer. Just for a look, this was the prayer. The exact prayer was, permit the appointees not found to be tainted to continue service till the end of the academy, because they were in a complete mess, the state, how they can run the school. So that was their prayer. In that context, first part was, Lordship kindly see that if kindly take the ordering portion, first paragraph. We are inclined to accept the prayer made in the present application, so far as it relates to assistant teacher for classes 9, 10 and 11, 12, not found to be tainted, subject to the following conditions. The condition number 1 was the advertisement to be made. Condition number 2 was the examination and the entire recruitment process shall be completed by 31st 12. Condition number 3, Board of Secondary Education and West Bengal Central shall file their respective affidavits. Then, board. So let us not go that technicalities. My learned friend was correcting me that this application was made by the board.
Whoever, no,
I
yes.
say that it makes the same thing. Ultimately, it's the order of the Honorable Supreme Court. 4, in case the advertisement is not published by 31st May and the affidavits are not filed by that date, appropriate orders will be passed by this court, including imposition of cost and vacating of the present order. Vacating of the present order means first line of the order, that allowing the prayer filed in the MA. After that, this is the importance. So in the context of 17th April to December, the continuance of the teachers, now Lordship read, we clarify that this order shall not be read as conferring any special right or advantage on the aforesaid teachers in so far as the fresh recruitment process is concerned, meaning thereby, yes, Honorable Supreme Court are allowing the teachers to continue from April to December. But that continuance, to my understanding, cannot be counted in any form, not even in the form of an experience, not even in any other form that I was there, any kind of right, nothing. So therefore, this word, we clarify that this order, therefore this order of allowing, it will not give any special right or advantage. This advantage means this continuance after 17/4/2025 up to this
31st
December. This has got nothing to do with the past experience of the untainted or not specifically found to be tainted. How that can be also found, consistency, Lordship might see. Kindly take page 376. That is in the 3rd volume. Another order of the Honorable Supreme Court.
Yes.
Well, this is an order dated 29th of August. So on 29th of August, in fact, I would be relying on just the order passed on 21/8, but that is quoted here. That's why I'm showing the one document. 376, kindly see. By order dated 21/8/25 passed in SLP number such and such, this court directed, well, this is the order 21. We direct that in the meanwhile, well, this is important, all selected and appointed, it is not for everyone, it is not for all participating, untainted candidates who were permitted to continue in service, that is, this permission was based on 17/4, I just placed, till 31/12/25, shall be allowed to participate in the fresh selection process without insisting upon their complying with the newly introduced eligibility criteria of securing 50%. Now that other part I am not going. I am only on these two parts. 17/4, the Honorable Supreme Court did not allow this continuance to non-teaching staff. Supreme Court only allowed it for the teaching staff, 9, 10, 11, 12. And this 21/8 order, this further relaxes, not for everyone, but for selected and appointed plus untainted. it's not that whoever participated in 16, they are going to get the same benefit. In that light, if Lordship kindly take it the same thing, the order passed in the review of Boishaki by the Honorable page 502. Sorry.
Fourth volume. Volume 4.
Yeah, exactly. My page 502, this is the order. The order starts from 507. 7 naki eta dekho to. My 2.
501 it
Five,
starts.
Lordship is saying 501 is the last page.
It's the first page. It starts with order.
Yes, but that one. So kindly come to this 501 is the order passed in review. Kindly come to 502.
Yes.
502, my lord, somewhat after 10 lines.
Yes.
Little right hand side, however the interest.
Yes. Yes.
However the interest of the, kindly mark again, the same thing. Appointed candidates who were untainted were sought to be protected to the greatest extent possible, as is evident from the concluding paragraphs of the judgment. No doubt, invalidation of such untainted appointments would lead to heartburn and anguish, which the court was fully conscious of. But protecting the purity of selection process is paramount and necessarily has to be given the highest priority. Last but not the least, the adverse remark made against the authorities concerned who were wholly, next word I am on, wholly and solely, because that's something institutional fraud minus the tainted, not attached by the Supreme Court also with us. Wholly and solely responsible for this entire imbroglio, adversely affecting the lives of thousands of candidates, untainted and tainted, were fully warranted and justified. And the last is Lordship's, this 2611, that's the last order when it was ultimately sent before your Lordship. This is volume 3, page 391.
Yes.
Kindly see, my lord, here. The first two paragraphs I am not placing because it's not necessary for the purpose that I am saying. From the second page, it would be open, but that is also not necessary. After that, the High Court shall, however, ensure that none of the tainted manner. This is also not necessary because this is now well known and Lordship is doing it. Kindly take the next page, my lord. This starts from the High Court shall examine the matters. 392. 392.
Yes.
The High Court shall examine the matters uninfluenced by any of the observations on merits made by this court in the orders passed after decisions in Boishaki. And next, this is important. The High Court shall also be mindful of the fact that the untainted candidates in the past selection, this past selection is not the 16. This past selection is for who were allowed by the court based on that 17-4 order. In the past selections were allowed to sit for the selection test to be held afresh, and their candidature cannot be adversely affected. Because initially, my lord, I had a feeling that this past selection refers to 2016.
Is it not?
May I read? Initially, a couple of times I thought that exactly that. May I read? Because that was my impression. The High Court shall also be mindful of the fact that the untainted candidates in the past selections were allowed to sit. Kindly mark the word allowed. The Supreme Court did not allow everyone to sit. Supreme Court allowed it only for the untainted persons. And by an order of the Honorable Supreme Court, the Honorable Supreme Court also relaxed certain conditions for those candidates who were untainted but appointed. Because the circle is more. Circle is wet list, circle is participating, but from the bigger circle, Supreme Court only chose this benefit to be given to appointed untainted. Now, therefore, the word allowing may not have any meaning if Lordship reads it of 16, because in 16, no question of allowing anyone. Everyone was there. So, in that context, if Lordship read it, the High Court shall also be mindful of the fact that the untainted candidates in the past selections were allowed to sit because they were allowed, just because this order was after Supreme Court allowed it, then they also sat, they could sit it after that relaxation, for the selection test to be held afresh, and their candidature cannot be adversely affected by application of new rules. In any case, well, I would be making these submissions. My first submission before your Lordship is thinking of, there is a possibility of reading it otherwise. But there is a possibility. I don't say that there is no possibility. But then Lordship has to somehow drop the word allowed. Well, I also read that.
Why? If we do not drop, then what happens?
If Lordship doesn't drop that, then it becomes like this, that the High Court shall also be mindful of the fact that the untainted candidates in the past selection were allowed to sit. Now, question is, it is were allowed to sit is an adjective kind of, it's a character.
Were allowed to sit by virtue of the order passed on 3rd of April. It has to be
Yes.
read.
Yes.
If
Yes.
you read it that way,
Yes.
then it's the
Yes.
same.
Yes. I want to read in that way. That by 3rd April, they were allowed to sit, and relaxation was not given to everyone. Relaxation was given, Lordship has seen in the previous order, those who were appointed lost their job and they are untainted, not everyone. So therefore, they were allowed to sit. So far as if Lordship reads it, because I was trying to understand, because in an interpretation, my Lord, in fact, every time if someone reads, leave 2-3 days, after that he reads, anyone might have a different interpretations. But as on today, my Lord, my interpretation is tilted towards the fact of allowing by the Honorable Supreme Court, and therefore this past selection is really not referring to the selection of 2016, but that selection where it is because of the Honorable Supreme Court, some persons could get a chance. That's an act of allowing happened. So I would make an interpretation in this way, that the Honorable Supreme Court wanted couple of things which are required to be taken into considerations by your Lordships. Thing number one, it is not the orders after the main order. It is the main order, that is the 3rd April's Boishaki's order, not the subsequent order. But even if Lordships look at the subsequent order, that 17-4, where Lordship has specifically asked question, that no advantage, that advantage was from April to 31st December, not the advantage of the for entire 5 years or whatever number of years. In any case, this order, I would say that the Honorable Supreme Court, all that wanted that we have allowed some candidates, and while allowing that candidates, we have also relaxed certain conditions, despite the rule requiring otherwise. Lordships need to just consider that. I put it that only. Therefore,
the commission ought not to do anything so that the candidates who have been allowed to be permitted to sit in the fresh selection gets debarred or becomes ineligible for participating.
I exactly this. Whoever Honorable Supreme Court has allowed, Lordships be required to just take into account that. It's not that the Honorable Supreme Court has in any way say that it has to be in this direction, that direction. Thus, take note that this is we have allowed. That's all. So therefore, if there is a kind of if Lordship, if I go back to that 17.4 observations, because this was an quite submissions showing 17.4, that is at page 230, that we clarify this order shall not be read as conferring any special right and advantage. So if I can sum up this submission, this order in the context of a temporary continuance and temporary continuance only, and this order has got nothing to do with whether in the rule a prior teaching experience can be said to be some constitutionally invalid advantage being given to others. That's not even the I would say context or anyway intended by the Honorable Supreme Court. That's I thought I should. This is my answer to that. Now, my lord, I would go to the rule itself, that possibly Lordship is seeing the copy of the rule from separate 2025 rule. No, I have the copy, but Lordship must be
I have
from the day one. Lordship was marking it.
Yes. এটা রেখে দিন তো।
Page number 346.
Because the marking pages, my lord, if that is not found, I think we lose track actually. And there lies, as I often say, there lies, my lord, in 3-dimensional. For an example, I can, like this page, I know it, what is the middle of it. So I know it is not going to be a very heavy document. So therefore, even if I am partially blind, I can come somehow the middle of it. But if it is in the lesser dimensions, that now in the iPad, there, whether it is 50 pages or it is a 500 pages, now I don't know.
Yes, the rules.
Yes, rules. But on the rule point, there are 3 issues. Issue number 1 is whether prior teaching experience itself is unconstitutional and violative of Article 14 or not. Now, some parts
been argued
exactly. Exactly. That's what I was about to say. That this issue has substantially been argued, and I also made some submissions. So I don't want to say anything on that. So I just wanted to say what is that, and I would make submissions what is left over only. Now there are 2 issues, that assuming that this is valid. If it is valid, then interpretation is always open. Then it is in accordance with the rule itself. Now there are 2 possible interpretations from 2 sides. The one side, that the petitioner sides are of the opinion that the rule, freshers, I put it freshers, of course, they feel that the rule says it should be included before the interview list is prepared. Whereas that we who are not the freshers, Our interpretation is no, it should be,
It's just the opposite. They want it at the
they-
time
they-
of
they-
final merit list, and you want it prior to the
yes, sorry.
interview.
They wanted that it should be done at
Later
the end.
Mm.
Now we say that
It should be done now.
it should be done now. Now my answer to what the rule says. Well, I would say from two stages. I would say if the rule becomes intra vires, which is the assumption now, then whatever the rule says, even if well, sometimes it rule might look good, it might give somehow we might think it is there is a better way of doing it, but if the rule itself is that so, then it has to be done in accordance to the rule itself. So my endeavor would be that rule says it should be included prior to preparing this interview list. Why I am saying so? I am saying so because of the two reasons. My reason number one is there is a substantive provision in the rule which says that interview list should be made on the basis of what? Number one. Number two, that substantive rules also refers about schedule which has a sequence and the buckets. And number three, same substantive rule with a different provisions also addresses where the merit list has to be made. Therefore, interview list and the merit list being completely two different things operating separately by the substantive provisions, there any stretching of interpretations based on the interpretational clause may not be proper. May I just show this and I will straight away go to the judgment on this my proposition. I say that the substantive provisions, I said the substantive provision is, kindly take 11 Roman 8.
Yes.
The Central Commission shall prepare and publish in its website a preliminary list with details of candidates to be called for interview. So therefore, this is clear, to be called for interview, subject to verification of credentials and eligibility category wise on the basis of, now this is the bone of contention, on the basis of preliminary merit score as defined in Rule 2(1)K and K alone. Therefore, my respectful interpretation would be 11(8) is an absolute clarity how this list for interview has to be made. It says that it has to be made on the basis of the preliminary merit score. I would say, so therefore, it has three pillars. One, pillar number one, for what purpose? So answer is the purpose is the interview. The pillar number two, on what basis? The basis is preliminary merit score. And pillar number three, it refers to which? Then it refers to Rule 2(1)K. Now this substantive provision, when Lordship look at with the schedule itself, Lordship gets the sequence. Kindly take my schedule 2. So schedule 2, the sequence is number 1, written examination. This has taken place. So it was in the sequence, it is number 1. Number 2 is the academics that I have referred as a bucket. Now educational qualification, it is not number 3. It is something, a component within the bucket of the academics. And there, my lord, this marking, and that is small a, and then small b. So therefore, kindly see thereafter number 3. So sequence is number 1 equals to written examination, number 2 equals to accumulations of these under small a and small b. Number 3 equals to oral interview, for which a list has to be prepared. And number 4 equals to lecture demonstration. So therefore, under schedule 2, this sequence, it clearly matches and very much in sync with the definition as well as the substantive provisions. Now, only problem, if I can use the word, only problem or the point which can be said is that in that case, what meaning I give to the definition of the merit list, because that can be one of the very reasonable submissions. Lordship, may kindly take the definition of merit list. Because that is, this definition is that their entire, if I can use the word, entire oxygen for demonstrating that it should be post, not pre. My lord, my first submission is the stage that Lordship is interpreting is whether it is pre or post for interview list. Substantive provision does not refer for anything of the merit list at all. Sequence also gives a clear clarity how it is to be done. Now, in that context, if I read merit list, in respect of SLST, such and such means, in case of posts, a list of candidates prepared category-wise on the basis of merit, which shall mean, in addition to what has been stated in Rule 2(1)K, marks obtained in oral interview, lecture demonstration, and prior teaching experience, and shall not include all the, this is not relevant. It doesn't talk about the sequence first. It's like, what is a merit list? So it gives a definition of merit list, whatever has been said in addition, because ultimately when the merit list is to be there, that will contain everything, because that will come later on. If I read it once more, my lord, for my understanding, I would read this way. First, merit list definition does not say anything regarding how to prepare the interview list, number 1. Number 2, it says that merit list in respect of SLST such and such means, in case of post, a list of candidates prepared category-wise on the basis of merit. Kindly pause for one moment. So therefore, merit list simply means whatever is prepared on the basis of merit. Now, pausing for a moment, if Lordship have a comma here, now what is merit? If I answer in this way metaphorically, merit is A to Z. Instead of saying A to Z, they have said it means, it shall mean, in addition to what has been stated, because it is stated about the interview list in Rule 2(1)K, marks obtained in oral interview, lecture demonstration, and prior teaching experience. Now, this is the troubling part. This is the troubling part, that and shall include all the eligible candidates. So that means, kindly look at this point of view.
Keeping in mind the submission of the petitioners that if prior teaching experience was not mentioned in the interview list, it has been mentioned for the first time in the merit list. So it should be taken up for consideration at the time of preparation of the merit list. Otherwise, you have to give benefit twice. In the interview list stage also, you are giving the prior teaching experience marks, as well as in the merit list stage also you are giving.
But that is, firstly, that is it cannot be, because then this sequence in the schedule has to be broken. It cannot be. One of the, in my understanding, harmonious way of looking at it is this, that for, if I go to schedule, then Lordship will get it. schedule. Hmm. Mala, this is one rule under the schedule also for 9-10, also for 11-12, and also for upper primary. Now in upper primary, in the sequence, the prior teaching experience comes last. So therefore, it is like one rule which has thought to be different for different sectors. I'm not for the time being on right or wrong. All I say that what the rule itself. So therefore, for A and B, that is for 19 and 11-12, there is a one stream which is pre. If Lordship kindly have a look at the sequence in upper primary under C, kindly come to schedule. Schedule, there are, my lord, three, one capital A, capital B, and capital C. Kindly take capital C.
Yes.
Capital C, selection to the post of assistant teacher for upper primary level. Lordship need not read. Kindly straightaway come, kindly see the sequence. Number 1, academic score. Number 2, TATE weightage, which is the different for them. Number 3, written examination. Number 4, oral interview. Number 5, lecture demonstration. And number 6. Therefore, the rule it is one which is trying to give some definitions for two separate categories. Keeping that in mind, if Lordships kindly come to the definition itself. Kindly come, my lord. Now, here is the role of rule 2.1 itself. That in the rules, unless the context otherwise requires. Therefore, my humble submission before Lordship would be this. This is one rule for two different categories. I would say 3 different categories. Under 3 different categories, they have chosen to go for 2 categories in one directions and 1 category in a separate directions. But they have chosen to give one definition for everyone. So while giving the definition of the merit, all they wanted to say merit equals to A to Z. Meaning thereby, merit means whatever we have said before plus ABCD which are applicable. In case there is a conflict, the answer lies, Lordships are required to see first whether, because for every definition it may not be there. First is this definition has to be used unless the context otherwise requires. Therefore, if the context is, here the context is the SSC is preparing the interview list, what they are required to do. My humble answer would be they are required to see what is the rule and they are required to follow that. And the answer is for that, my lord, the rule 11, that is to be followed. And once that is followed, Lordship doesn't find the definition of merit coming into play. Now, one apprehension may come. Does it mean that they will get again marks? My answer would be no. Why it is no? Because the sequence and the schedule has to be followed, number 1. Number 2, even if there is a conflict language-wise or otherwise, then it is the substantive provision which is required to be followed. And for merit, if Lordships kindly once more come to 11.8 equals to today's situations. That's the interview list, 11.8. Now, there is a separate situation also for the merit, that is Roman 16.
Yes.
Kindly see post-interview. After interview, the interview board shall forward a detailed report to the Central Commission, which shall form the interview list, and on the basis of the report of the interview board, prepare, publish a merit list, categorized on the basis of the merit as per Schedule 2. The moment, kindly, my lord, see this part, as per Schedule 2, I would read this way, as per Schedule 2, A, B, or C. The moment it is A, B, and C, there is no scope of going differently or double, because A has single, B has single, and C has single, but differently. For A and B, it is similar way. For C, it is last. Well, to that, there is a judgment. Judgment. Well, at first judgment, which one? Upper. This is, yes, 1985, SCC Online, Bombay, 256. I shall be relying only two paragraphs, 22 and 23. This is for the purpose, unless context otherwise says. According to my submissions, it doesn't. But in case, my lord, there is any iota of conflict being there, then my lord, the interpretation is this. Paragraph 22. Francis Benyon in his treatise Statutory Interpretations 1984, such and such page, whether the defining enactment says so or not, a definition applies only where the contrary intention does not appear. I am only on that part. This is because the legislation is always free to display a definition. Disapply. Correct. Because the legislator is always free to disapply a definition, whether expressly or by implication. Lordship need not read the others. Kindly come to 23. It is precisely to meet such contingency, the definition clauses invariably limit the scope of the definition by using the expression unless the subject or context otherwise requires, or some such qualifying words as let down in such and such. The interpretations clause should not be understood as requiring, now this is the point, it should not be understood as requiring extended meaning in all circumstances, for the definition clause itself says unless the context otherwise requires. However, even where such an expression is employed, it is only where the contrary intention appears from the context that the definition clause may be given a go by and the word understood as is understood in common parlance. But then, as stated above, when the definition, that's not. In this context, Lordship will not find a different intention is appearing in Schedule 2 or in Rule 11. Absence of merit list in Rule 11 is the clarity to follow Schedule 2 sequentially. Well, next is 1980, 1 SCC 321. Only one paragraph, paragraph 24. Paragraph 24. A definition clause does not necessarily in any statute apply in all possible contexts in which the word which is defined may be found therein. The opening clause of section 2 of the Principal Act itself suggests that any expressions defined in that section should be given the meaning assigned to therein unless the context otherwise requires. Well, there is one more judgment. Okay, two more. Mothu. Well, 9. Well, there is one judgment. This is the Vanguard fire. This is not reported. It is taken from the Honorable Supreme Court's website. This is a copy. Paragraph number 5. Sorry, this is not paragraph because there is no paragraph number. There is page 5. SLP number to give. Well, from it is well settled that it is there is one first paragraph, Lordship may skip. Thereafter, another. It's referred about section 33. Lordship may skip.
It is well settled.
Yes. It is well settled that all statutory definitions or abbreviations must be read subject to the qualifications variously expressed in the definition clauses which created them. And it may be that even where the definition is exhaustive, inasmuch as the word defined is said to mean a certain thing, it is possible for the word to have a somewhat different meaning in different sections of the act, depending upon the subject or the context. That is why all definitions in statute generally begin with the qualifying words similar to the word used in the present case, namely, unless there is anything repugnant in the subject or context. Therefore, in finding out the meaning of the word, here context was insurer, in various sections of the act, the meaning to be ordinarily given to it, it is that given in the definition clause. But this is not inflexible, and there may be sections in the act where the meaning may have to be departed from on account of the subject or context in which the word has been used, and that will be given effect to the opening sentence in the definition sections, namely unless, well, that part. So the last one is 1997 to SCC 53. Paragraph 12 and 13. Paragraph 12 and 13. Where the definition or expression as in the instant case is preceded by the words unless the context otherwise requires, the said definition set out in the section is to be applied and given effect to. But this rule, which is the normal rule, may be departed from if there be something in the context to show that the definition could not be applied. Why I'm making these submissions? Because my understanding is the merit list equals to A to Z, all, no repeat. By stretching the definition of merit, if an interpretation is sought to be made that it would make a twice prior teaching experience, Lordships can very well, even if there is a conflict, Lordships can very well take that interpretations saying that I would not go only with the definition of merit itself. I will take merit as whatever has been said above plus whatever is left over. That is merit equals to all and the preliminary equals to whatever said before that. And 13 is, this court in such and such case, while considering the definition clause of the act, which is under our consideration held, A definition clause does not necessarily in any statute apply in all possible context in which the word which is defined may be found therein. The opening clause of section 2 such an itself suggests this is the same thing which has been said. Well, on this topic, there is no other judgments. Now, I shall be placing the judgment on the directly on prior teaching experience point. My first judgment that it is valid. First is Sachibala.
Quite a few has been referred possibly in Orunima, Paul.
Which one?
This prior teaching experience is permissible. It is perfectly done. No issues.
Yes,
the others have also referred to.
Yes, division. What I am trying to address is that because I thought that I would be ending with that this rule was challenged. The point of prior teaching experience was also canvassed before the honorable single judge. The fact of challenge of the rule was given up before the honorable division bench. Prior teaching experience was canvassed. The honorable division bench also there is one detailed paragraph that it is okay. Experience is something intelligible differentiate is there, that is expressed there, and ultimately it's not that it was interfered by the honorable Supreme Court. But I was also making an effort, assuming nothing is there. I was, because it's not an interim purpose. Lordship is going to deliver a final judgment. Of course, that's one of the good points in our favor. Leaving aside that also, when Lordships look at the issue as if it is absolutely a fresh issue which has not been touched by any court before at all, even then, there is an every possibility that Lordship might echo with the same saying that Maladi, I would put it in this simple words that once there is a recognition that experience is different, the fact of some weightage being given to that experience, irrespective of the fact that that causes the competition becomes harsher for some others or it becomes tougher for the freshers, Lordships may choose not to interfere with in the light of the Article 1416 by saying that there are differences. Some people have more experiences, therefore they get weightage. You become a better student and you fight in the dominant factor of this. On that context, yes, Lordship is absolutely right. In Orunima matter, division bench have said so. I have that judgment also. But this is the judgment where 2017 11 SCC page 421. On past service point, straightway paragraph number 21.
Which paragraph?
Yes,
is it?
paragraph
21.
paragraph 21.
Yes.
Before that, for lit, but I think I'm trying to go to the exact paragraph. So therefore, paragraph 21, the first respondent who was a party to the settlement recorded by the High Court in its order dated such and such could not be permitted to raise the question of enforceability of the settlement, more particularly when all that the appellant seeks is only weightage for the past service of its members, which the first respondent agreed. In principle, I'm on the in principle point, to give to similarly situated persons working with other departments. The members of the appellant union have been working with the first respondent for long periods, period varying from such and such. Whether such employment was regular or irregular in law is a different matter. Well, because there was one of the submissions from petitioners was the Honorable Supreme Court declared it to be void. Does it mean that our act of teaching, or if I can say this, does it mean also that our entire experience also becomes void? My first answer is the Honorable Supreme Court have actually, while dealing with untainted, with two categories, kept even the past service who had an old job and allowed us to participate. And in that context, state chose to make a rule to give an weightage to all the persons whoever has got the past experience. In my understanding, my lord, that does not violate at all. My lord, next judgment is 2024 2024 SCC online SC 3540. It was by Justice Dotto and Justice Mahadevan. Paragraph 29. But the context can be found from, I'm not reading all paragraphs, 25, 26, 28, but ultimately Lordship will see that very short, as we are applied to the constitutional mandate prescribed in Article 14 and 16 read with a preambular promise of securing social justice, we hold that non-grant of mark for experience to the first respondent was not proper and legal. So therefore, there was an affirmation. Next, whatever. But this is, Lordship also kindly take 28 also. In this case, for the foregoing reasons, refusal to award any mark for experience to the first respondent would go against the grain of the constitutional duty of ensuring equality and securing social justice for the deprived. My lord, next judgment is 2018 13 SCC 560. Paragraph 33. (2018) 13 SCC 560, paragraph 33.
Yes.
Question now is whether in the absence of any right in favor of Shikha Mitros, they are entitled to any other relief or preference. In the peculiar fact situations, they ought to be given opportunity to be considered for recruitment if they have acquired or they now acquire the requisite qualification in terms of the advertisement for recruitment for the next 2 consecutive recruitments. They may also be given suitable age relaxations, which has been given to us also, some of us, I would say, who required it, and some weightage for their experience as may be decided by the authority concerned. This is not a case where there is a rule itself. All I'm trying to say, there is a recognition of experience and thereby some consequential benefit which can be given without affecting Article 14, only that part. And then this one. This is, my lord, this is clear cut 2016 SCC online, Rajasthan 646. Paragraph 6 first. Before coming to the facts, it would be appropriate to mention that the concept of equality enshrined in the Constitution of India does not forbid reasonable classification for the purpose of legislation. If any classification is made which is founded on an intelligible differentia, it distinguishes persons or things that are good together from others left out, and the differentia may possess a rational relation to the object sought to be achieved by the statute in question, then that does not offend the concept of equality. The concept of equality does not take away the authority of the state to classify the persons for legitimate purposes. If a law deals equality with members of a well-defined class, it is neither obnoxious nor a denial of equal protections given under Article 14 of the Constitution. Thereafter, my lord, a 5-judge bench of the Honorable Supreme Court in Chiranjit Lal was referred, same page, paragraph 7. I'm not reading it, the last paragraph. Lordship may kindly mark paragraph 7, the last portion in Chiranjit Lal versus Union of India. That's a constitutional bench judgment. After that, ultimately, thereafter, paragraph 12. In view of it, we are of considered opinion that the persons having experience on similar work under the government, National Rural Health Mission, and Medicare Relief Society form absolutely a different category. And the classification made under the proviso impugned is not at all discriminatory. This was upheld by the Honorable Supreme Court. Tell me paragraph. Well, last one, 2021, 15 SCC 401, paragraph 61. Before that, Lordship may also kindly take paragraph 54.3. Should sorry 54.3 and 61.
Yes.
And this is directly, the question was freshers versus someone who was working. 54.3, should there not be a different yardstick for Shikha Mitros who had been rendering services as teachers as against what could be applied for fresh graduates? Now, in that light, the answer is at paragraph 61. Relying on the decision of the court in such and such, it was submitted that Shikha Mitra who had been discharging their services as teachers could not be put at the same level with fresh graduates having such and such qualifications. In that case, this court was called upon to consider setting aside of certain seats of the state government for in-service candidates in postgraduate courses. It was observed by this court, thereafter, this is a quote, and Lordship may skip that and kindly straight to come to last paragraph of the same page. This court was considering validity of certain percentage of seats earmarked for in-service candidates, and it found the classification to be correct, having nexus with the object of ensuring availability of competent professionals in the rural parts of the state. On the other hand, the object of giving opportunities to Shikha Mitros was to ensure that they are given fair chance to compete with others so that the best of the lot would be available to take care of primary educations in the state. In our view, the submission does not deserve acceptance. Question C set out such and such is answered accordingly. Well, these are my judgments on prior teaching experience point. Well, next is having participated. No, having participated. Physical. Well, first is 2019.
Which proposition?
Yes. Well, all of them, they have participated.
And now they question the selection process.
Now
and
they
the
have, Lordship may look at from two views. One is they are questioning the constitutionality. The other view is, while questioning the constitutionality, they are also questioning the method of the recruitment, because the marking was well known to them. They participated. Now they are. So in that context, I want to say, having participated and knowing fully well about the method, now possibly they cannot question it now. In that context, first 2019, 15 SCC 633, paragraph 21 and 22. And 22. Paragraph 21 and 22. First 21. There is one more aspect of the matter which need to be noted. The applicant was well aware that under 30% LDC quota, out of 5 vacancies, 4 are unreserved and 1 is reserved, which was circulated by notification dated such and such. She applied the said bifurcated vacancies and was interviewed on such and such, panel of which was declared on such and such, and promotion was made on same day. She, having participated in the selection for promotions under such percentage quota and bifurcations of the vacancies, being part of the process of selection, it was not open for her to challenge the bifurcations of vacancies into general and reserved after taking a chance to get selected. In this context, reference is made to judgment of this court in Ashok Kumar versus State of Bihar. Then, my lord, the court, the law on the subject has been crystallized in several decisions of this court. In Chandraprakash Triwari, this court laid down the principle that when a candidate appears at an examinations without objection and is subsequently found to be not successful, a challenge to the process is precluded. The question of entertaining a petition challenging an examination would not arise where a candidate has appeared and participated. He or she cannot subsequently turn around and contend that the process was unfair, or that there was a lacuna therein, merely because the result is not palatable. In Union of India versus Binod Kumar, this court held, it is also well settled that those candidates who had taken part in the selection process, knowing fully well the procedure laid down therein, were not entitled to question the same. But in fact, I would not read the entire paragraph because it is same propositions spread over everywhere. Ultimately, 22 with us, due to above both reasons, are of the view that the tribunal and the High Court ought not to have entertained the stale claim of the appellant. Well, on this proposition, my next is 2013 11 SCC 309. Paragraph 18, 19, 21, 22 and 24. I shall be referring to paragraph 22. I shall be reading 22, referring all, but not. Well, I'm reading only one paragraph, but I'm relying the all others also. 22, in Manish Kumar Shashi versus State of Bihar, the court reiterated the principle laid down in the earlier judgments and observed. We also agree with the High Court that after having taken part in the process of selection, knowing fully well that more than 19% marks, this is the, here it is 10 marks, more than 19% marks have been earmarked for viva voce test, the petitioner is not entitled to challenge the criteria or process of selection. Surely, if the petitioner's name had appeared in the merit list, he would not have even dreamt of challenging the selection. The petitioner invoked jurisdictions of the High Court under Article 226 of the Constitution of India only after he found that his name does not figure in the merit list prepared by the Commission. This conduct of the petitioner clearly disentitles him from questioning the selection, and the High Court did not commit any error by refusing to entertain the writ petition. So, same proposition. The other judgments on the same propositions is 2017 9 SCC 478. Paragraph 4, 6, 8, 10 and 11. I would be referring all, but I shall be reading only one paragraph, paragraph 11. As far as the present case is concerned, an advertisement was issued by respondent number 6 inviting applications for the post of music teacher in such and such school. Respondent 1 did not raise any objections at that stage that the post could not be filled in by direct recruitment and she should be considered for promotion. Not only that, she is in fact applied for the post and took part in the selection process. After having taken part in the selection process and being found lower in merit to the appellant, she cannot at this stage be permitted to turn around and claim that the post could not be filled in by direct recruitment. The reasoning of the learned single judge in rejecting the objection is not in consonance with the law laid down by this court. In view of this, we need not go into the other issues raised. The last one is 2022 1 SCC 294. This is by a larger bench comprised of 3 honorable judges. 2022 1 SCC 294, paragraph 35, 36, 37 and 45.
30, please repeat. 35.
35, 36, 37 and 45.
Yes.
Well, I'm not reading it because it is
Reiterating the same thing.
Yes, same thing. But only purpose of this for 2, that this matter being even had it been any other matter, maybe I would have brought only one judgment, so that my sentence
Consistent view of the
that I'm not picking up and saying that I got a judgment and therefore I'm placing. No, this is the consistent view. So only that purpose.
কি কথা বলছো ওদিকে? The clock is ticking.
Yes. Well, I might take just 10 to 15 minutes.
Another 15 minutes?
10 minutes, because I have almost finished. I would wrap up with 2 things. One is that Orunima, in fact, that I have with me. And I might take just 5 minutes to sum up, and not 15 minutes by clock.
May I request only, because I believe all parties are.
1 minute. Tell me one thing. The commission is here. Whether the disclaimer has been published?
Yes. Another thing is the substance.
Because this is troubling the court. The time is going. The 31st is the date. Nobody knows which side it will tilt. It involves thousands and lakhs of candidates participating. The commission should keep the data ready. I will require the data, the number of candidates participating, the freshers, the old ones, and everybody. The percentage, how have they fared and everything. For giving a proper judgment, these data may be required. As and when stages come, these ideas come to your mind. I cannot offhand say, but then since the arguments are advanced, I have to think over it.
That I would be also requesting Learned Advocate General to have the statistics that by percentage wise for out of total 35,000, how many freshers have got and
Yes.
how many, so that some
You
rough
will
idea.
not be able to say the commission
Yes,
is
yes,
here.
No, sorry.
The commission will say.
I just,
If they make it in a tabular form that
Yes,
in
yes.
each and every subject
Right,
matter,
right.
give an idea without,
and another
It will be easy.
yes.
Everybody also
Yes,
gets to
yes,
know that
yes.
this is the picture and why this judgment is coming. Otherwise,
Right.
various questions
Correct,
nowadays.
correct.
Why
Yes,
this?
yes.
Why not this?
Yes, true.
and another thing, substantial amount is taken.
Substantial amount.
Some time already taken by the all the
Parties.
parties because if everyone is agreed on make it part otherwise if
Yes, 100%.
I have
We have, we can't afford
mentioned it on the last occasion that the court has consumed a lot of time in this
we would
matter.
be doing an
Assuming
injustice.
the bench
Yes.
gets changed,
Please.
it will be an
Take it as a
understanding
part
that
of-
it has been substantially hurt by this bench. Now, if somebody says no, it has to go, it will go. Certainly, a court cannot hold on to the
I
matter.
want it because I have spent lot of time. I understand the precious judicial. Kindly treat it as a
Judicial hours, valuable, very
Yes,
valuable
yes,
judicial hours have been spent on this.
So kindly,
I'm not recording heard in part. Let's see what happens.
Lordship can record it. What is the
otherwise we both the parties agreed, my lord, or
No,
by
it's not.
consent.
No, it's not both. There are many parties.
Commercial, every party.
There are many parties. I'm not recording it formally, but then let it be
in case anything happens, or
considered.
if
Yes. In case there is change,
Yes,
in case there is no change, it's going on. I do not know whether there'll be a change or not. Nobody knows.
One indulgence I will be paying because I am in the situation that possibly tomorrow my turn will come. But I have fixed two matters tomorrow, at least 2 weeks back. One is fixed at 2 o'clock, the other is fixed at 3:30.
Morning. Morning.
I should inform the court that tomorrow,
Difficult for you.
because I cannot finish in a half. Otherwise,
Other matters have to be given some amount of time. The entire second half is consumed here.
Could your lordship accommodate me in the day after tomorrow?
Let us see. Day-to-day hearing will be
Yes.
possible or
If
not.
the situation comes
Yesterday, I didn't take up this matter. I kept at least one day in between to take up other matters.
Well, in one matter, this opposition, there was a little delay, so kindly one line.
I will condone the delay.
No, there is.
I will not take it as a delay. I'll permit
Yes, that.
those documents
That is in item
to
60.
come in.
60?
1 minute. Let me first
Yes,
think
yes,
as to when will be the next date.
না, 61 টা
Item 60? My mind and the calendar
Yes.
are not in the same line.
OMR published ইস্যুটা কালকে আছে না
Uh,
my lord, item number 61, that is Moshumi Mondal matter, my lord. There is a 261 Moshumi Mondal that went up to the Supreme Court, my lord, and Supreme Court freshly is taken up by this bench, my lord. Till date, already, my lord, pass an order to publish the 2025 OMR sheet. Till date, they not published it, my lord. Same prayer in Moshumi Mondal also, my lord. It will be kind enough. The matter will come up tomorrow, my lord. That matter, my lord. It will be kind enough posted this Moshumi Mondal item number 61 tomorrow, my lord, along with others, my lord, prayer.
all right. If there is an exception, the court will certainly hear. Please come. Are you a party in Lubana?
Yes.
Lubana,
Because I did not see your appearance on the last occasion. In Lubana, you are not there.
Lubana, I
All
have
right.
not.
All right.
I mean,
I indicate one thing, my lord. Lubana is filed because that having participated and rule can't challenge, but Lubana is filed much prior, just immediate framing of the rules. Lubana and Mosumi Ghosh.
Are the first matters?
Yes, madam. Lubana and Mosumi Ghosh, both the Ghosh Das, both the matter filed just immediate after the publication of the rule, my lord.
Lubana was filed at the time of Odunima's time. My lord, Odunima was heard, but Lubana was left.
All right.
Lubana and Moshumi Ghosh Das, both the matter, my lord, file at that.
Moushumi Ghosh Dash, which item is this?
Item number
Item number 62.
62.
62. Yes.
And
12,000.
thereafter, my lord, Bhim Sarkar and Choitali.
That is after fresh candidate. ঠিক আছে। Hard submission recorded in Lubana. এই যেটা হচ্ছে 56. Hard submission made on behalf of some of the job losers, untainted job losers.
Not specific like that.
Who participated in the second SLST 2025. Stop. Fix the matter for further hearing on. I'll take it to the 6th of January. Yes.
Then make it for one line, make it patad, my lord. My lord, with all the parties, my lord, agreed on that one.
Don't worry, it is part heard, but then I'm not recording it.
Then, my lord, item number 61. My lord,
এটা কে দিয়েছে? এটাতে 56 এ নেই, সেই জন্য দেয়নি।
পুরো বান্সটা।
That can be tagged together.
my lord, they are in
Lubana,
my matter.
let the petitioner say,
My lord,
then
my matter.
respond whether they are in the same lines or not.
My lord, I just to give the number. 56 Lubana Parvin, 59 Bhim Kumar Sarkar.
Before that, 58 also.
That is not my matter, so
No,
I
that's why, but
could.
I'm
Shishir Rahul.
1 minute. Shishir also.
yes, but I'm appearing also.
আচ্ছা তাহলে 56 57
No, my lord, 60 except 61. Except 61. 61, my lord, to put it tomorrow, my lord.
all right 56 57 58 59 60 and 62 except 61 updated in one order in that case.
Affidavit.
Some of the job losers will all right, so that will
63 also where
ওরকম ভাবে কিরকম ভাবে
Up to 62 except 61.
Up to 62 except 61, one item, one order is being passed, which will cover all. 6th of January 2026. You have difficulty this week and then the court's time may not permit. That is the reason. Now 61 will be there in the list tomorrow.
Tomorrow, yes.
All right. And 63 onwards, let it remain in the list as and when.
63 is identical.
that opposition.
63 I am for the record. Which applicant?
Applicant number 2, can 2.
Acha. Affidavit in opposition filed on behalf of the applicant in can 2 taken on record. It will be open for the petitioners to file exception to the same prior to the adjournment. Item numbers.
Copy দিও যদি আমাদের
Actually,
58, 59 and 60.
filed by the commission. Please circulate copies.
And I keep 63 also with this bunch.
Fine.
63 বলছে এই বাঁচে
63 also keep.
Well, 63, well, I have got a petitioner.
This issue is, my lord, the
11th.
60. My lord, the
different issue.
yes. 63.
This is also regarding giving of 10.
63 is the 10 marks or that 19 school
Are you the
teacher.
petitioner in 63?
Yes, yes.
Let it be separate.
He is the petitioner in
It is
63.
63.
This is also rule
Answered.
9,
There
10,
is
11,
the
12.
group challenge, but then whether 9, 10 experience.
Yes, yes, yes. That is.
For 11, 12.
He has not
This
challenged
issue has not been challenged in the other ones. 63 is separate. Yes, sir.
58.
64 onwards will remain in the list as it is. Your matter has been tagged up.
58 and another is not in the list that I had done yesterday.
Let it come. I am keeping matters in a staggered manner so everyone can come in.
I don't know different issue.
All right.
Okay.
All parties.
Respondent. Number
61 টা লিস্টে কালকে থাকছে and 63 না 63 অর্ডার হয়েছে হ্যাঁ you want কিন্তু তাহলে তো ওর ইয়েটা সাবমিশনটা তাহলে কোথায় রেকর্ড করা
মন্ডলের
63 opposition has been filed. You can file your reply. Whoever the petitioner is, you can file your reply. I'll fix it on the 6th of January.
Yes.
Exchange all your pleadings.
না না আমার যেটাতে